We're on the record. This is the digital video deposition of Victoria Sheele, Volume 2, testifying the matter of Duval versus County of Los Angeles et al. In the Superior Court of the State of California, County of Los Angeles Central District. This deposition is being held at 19301 Campus Drive, Santa Ana, California. Today's date is August 18th, 2014, and the time is 10:23 a.m. My name is Gordon Miller, Legal Video Specialist with Jordan Media, Inc. The certified shorthand reporter today is Jan Roper with Cram Court Reporting. All counsel will now state their appearances for the record.
Sam Park, appearing on behalf of Plaintiff Rafaelina Duval.
Richard Prager on behalf of the plaintiff, the record reflect that Ms. Duval is present.
I didn't even hear you. There's no microphone. Sorry.
Richard Prager for the plaintiff, and the record will reflect that Ms. Duval is present.
Desiree Schultz of Collins, Murray Stewart for defendant Victoria Sheele, as well as the other county defendants.
Thank you. The witness may now be sworn.
Yes, please.
Raise your right hand for me, please. You do solemnly swear that the testimony you're about to give and the cause now pending shall be the truth, the whole truth, and nothing but the truth?
I do.
Thank you.
Good morning, Ms. Sheele.
Good morning.
My name is Sam Park. Again, I'm one of the attorneys representing Ms. Duval in this case. We had a deposition last Thursday where you gave us some testimony to us. And one of the things you had mentioned was that as part of your duties, you were both monitoring visitations and you were also assessing Ms. Duval. Is that correct?
Yes.
Okay. So the portion I guess I'll ask questions about both, but one of the questions I have is, what do you mean by assessment?
Assessment is observing the interactions between the parent and the child.
Okay. Is there anything else that's a part of assessing?
That's what comes to mind at this moment. I'm sure
because it seems a little bit redundant when you say that you are both required to observe the witness, part of monitoring, and then also to assess the person you're monitoring. It seems a bit redundant to say that you're observing and then assessing is also another way of saying observing. So is that it in terms of what your understanding was of assessment?
Objection, argumentative, compound, vague and ambiguous.
That's what comes to mind.
Okay. Now, as part of when you are saying that you assess Ms. Duval, does that also entail giving your opinions about giving your opinions about Ms. Duval?
Objection, vague and ambiguous.
Okay. Does it involve? Does the assessment of Ms. Duval also involve your providing opinions about reasons why Ms. Duval may be doing certain things?
Objection, vague and ambiguous.
I need. It's too broad. I'm not sure what
Okay.
you're talking about.
Well, let's leave
Confused.
it. Let's just take it a step further back then.
Okay.
As part of assessing Ms. Duval, were you did it involve forming any opinion about Ms. Duval?
Objection, vague and ambiguous calls for a narrative.
Again, can you be more specific?
Okay.
I'm not sure what you're talking about.
Sure. How about an opinion regarding, for example, the credibility of Ms. Duval? Is that something that would be part of assessing Ms. Duval?
Her credibility in what way?
Credibility in anything that she is reporting, as part of the investigation.
I don't know what you're talking about, so it's hard for me to answer. I'm sorry.
Were you required as part of your duties to assess Ms. Duval's credibility in terms of, for example, things she might report about feeding her child, what she was feeding her child?
I was not assessing her credibility about what she was feeding her child. I was observing what she was feeding her child while I was present.
Okay. How about, as part of the assessment of Ms. Duval, were you rendering any opinion about Ms. Duval's fitness as a parent?
Objection, vague and ambiguous.
Rendering to whom? And I don't know what you mean by fitness. Fitness is apparent.
Well, for example, the child was not with Ms. Duval, was he?
No,
at the time? Okay.
not at that time.
And Ms. Duval was in the process of trying to reunify with her son. Isn't that also correct?
Yes.
Okay. Now, as part of the decision that DCFS is going to make, is one of the things that they're going to do is to make recommendations to the court.
Yes.
Right? And some of those recommendations might also include whether the child should reunify with Ms. Duval, correct?
I'm sorry, I think the way you're phrasing it, I'm not understanding
Okay.
it. Can you repeat it
Sure.
or rephrase for me?
So, as some of the recommendations that DCFS might make in a case like Ms. Duval's would be whether or not the agency recommends that the parent and the child should reunify. Isn't that also correct?
I don't know. I'm not understanding what you're asking me.
Okay. What
For
part
some
don't you
reason.
understand?
The part about DCFS making recommendations whether Ms. Duval should reunify or not.
Okay.
I don't recall whether we
Okay,
made.
let's start with the court
I'm
reports.
confused.
You recognize that there are court reports filed in these juvenile dependency cases by
Yes.
DCFS.
Yes.
Okay. And as part of those court reports, aren't there recommendations made by the agency regarding whether a child, for example, should be detained, whether a child should be reunited with their parents, whether reunification services should be provided? Isn't that true?
Yes.
Objection, speculation, compound, and vague and ambiguous.
Okay. So, with that in mind,
Mm-hmm.
was it ever a part of your job duties during Ms. Duval's case to render an opinion regarding whether Ms. Duval should be reunited with her child?
Objection, vague and ambiguous.
I don't know why I'm having a hard time with what you're asking me.
Okay. Well, did you ever form an opinion regarding whether Ms. Duval should be reunited with her son?
Did I form an opinion? I don't recall forming an opinion
Okay.
regarding
And
this.
it wasn't part of your job to form such an opinion either, was it?
Objection, foundation, assumes facts not in evidence.
I
Vague and
think
ambiguous.
it was my job to monitor visitation and to observe and assess the interaction between the parents.
Okay. Now, in terms of observation, your job wasn't solely to observe, but it was also to report, wasn't it?
My job was to write down what I observed
And where would you write these things down?
in the delivered contact log.
Okay. And the information that you put into the contact logs, are they strictly supposed to be facts, or are they supposed to also include your opinions?
They're
Objection, compound.
they're observations. It's what I'm observing.
And when you're talking about observing, would opinions ever form part of your observations?
Objection, vague and ambiguous.
I'm unclear what you're talking about opinions. What do you mean by opinion? Can you give me an example?
Well, for example, if you saw that a child was smiling and playing with her toys, you might note in the observation that the child is smiling and playing with his toys. A secondary opinion might be that the child is happy. So, were you ever tasked with formulating that type of opinion about what interpreting basically what you are seeing?
What I wrote is how it appeared to me at the time that I observed it.
Okay. Now, when you're saying observations, I just want to be clear. Are we just talking about what you are sensing, as in seeing, touching, feeling, or hearing? Or are we talking about, for example, I'll give you another example.
Mhm.
If you're to describe a car accident, you might see one car going through a red and hitting another car. One way that you might note the observation is the light turned red, one car proceeded through and he hit the other car. Another way you might characterize the incident is to say that person ran a red light and he hit that car and caused the accident. In other words, you're forming an opinion about what has happened rather than strictly describing the facts as you see them. Does that make sense?
Objection vague and ambiguous.
I'm having a hard time connecting a car
Okay.
accident to this case.
All right, let's just take it from a different angle.
Okay.
Were you tasked with assessing Ms. Duval's credibility in any regard during the
Objection.
pendency of the juvenile dependency case?
Objection vague and ambiguous.
Again, my task is to write what I see and write the facts as I observe them.
Okay. Were you tasked with assessing Ms. Duval's demeanor during the monitored visitations?
Demeanor would be part of observation.
Okay, and how might you describe a person's demeanor if you're writing down in a contact note what you're observing?
Objection vague and ambiguous calls for a narrative.
Well, just give me some examples, if you wouldn't mind that.
It would be based on what I'm observing.
Okay. So, can you just give me just a hypothetical example of how you might observe somebody's demeanor and notate it?
Objection vague and ambiguous. Incomplete hypothetical. Speculation.
I would observe your demeanor right now as very serious.
Okay, so
Leaning
that
forward,
might be how
serious.
you. Okay, so you would not simply say the person is smiling or not smiling. You would say the person is serious.
Objection incomplete hypothetical. Speculation.
That's fine. We'll just move on. What was the purpose of monitoring visitations as you understood it back when you were monitoring Ms. Duval's visits with her son?
The purpose of monitoring visitation is these were court-ordered monitored visitations.
Okay.
So
And-
we're following court orders by monitoring the visitation.
Okay. One of the things that I went through and looked at was your policy for supervised visits. What exhibit number are we on?
9.
Okay. We'll go ahead and mark this exhibit 9. And the Bates numbering on the top is DCFS CRU 292 through 295. Procedural Guide 0400-504.45, Supervised Visits. Before you were assigned as a monitor for Ms. Duval, was there any process that was followed to determine whether you were qualified?
Objection speculation. Vague and ambiguous.
If you know.
What do you mean if I was qualified?
Well, if we look at your procedural guide for supervised visits, it lists who may be utilized as a monitor and the qualifications of a monitor. Based on your recollection, though, do you recall whether you had to fill out any forms to determine whether you were qualified to serve as a monitor?
Objection foundation assumes facts not in evidence.
I don't recall. It's been a long time.
Do you know whether you ran whether there was any check that was performed to find out whether there were any conflicts of interest?
Objection speculation. Vague and ambiguous.
I don't recall.
Do the words volunteer monitor, professional monitor, and therapeutic monitor mean anything to you?
Objection compound. Vague and ambiguous.
Well, obviously, there are different kinds of monitor.
Okay. Do you have any understanding about what the difference is between the three types?
Objection compound. Calls for narrative.
I'm sorry.
And you can tell me generally.
Ask again?
Uh,
What are the three?
The volunteer monitor, the professional monitor, and the therapeutic monitor.
Off the top of my head, I can't give you definitions for those.
Do you know whether you were a volunteer monitor, a professional monitor, or a therapeutic monitor at the time you were monitoring visits for Ms. Duval?
I can give you my best
Sure.
guess, I guess. Obviously, I'm not a therapeutic monitor, and I'm not a, volunteer monitor? I'm staff.
Okay, we'll go ahead and mark that exhibit. Is it 9? Okay. When you were monitoring visits for Ms. Duval,
Mm-hmm.
was it your understanding that you needed to be complete, truthful, and accurate about everything you observed during the visit?
Yes.
Would there have been a problem for you if there wasn't, for example, another person to also ensure that monitoring the visits to ensure that the accounts of the visits were being kept truthful?
Objection vague and ambiguous.
Repeat that.
Actually, let's just scratch that.
Okay.
How long were you? Was Miss Duval's monitor visits the first time you had monitored visits before?
No.
Okay. In about how many cases prior to Miss Duval's had you been monitoring visitations?
I don't know. Off the top of my head, I don't have an answer for you.
Did you
I'd
start
have to look it
monitoring
up.
visits almost
I'm sorry.
immediate? Sure.
She was still speaking.
Okay, understood.
Okay, answer, I don't know off the top of my head, I don't have
the number of cases that I was carrying at that time.
Do you recall whether you began monitoring visits immediately after you started employment with DCFS?
What do you mean by immediately?
Well, shortly in time.
Objection vague and ambiguous.
How long did it take you after the start of an employment to begin monitoring visits, if you recall?
When I was first deployed by DCFS, I entered Corps Academy, so I was not carrying cases. So it was not until I came to the office on a full-time basis following my training that I began carrying cases and thus monitoring visits.
Okay. Did you receive any training other than the Corps Academy regarding how to monitor these visits?
Objection asked and answered.
I believe that was included in Corps Academy.
Do you know whether any of these monitor visits are ever recorded, whether by audio or video?
Objection, speculation, vague and ambiguous. Are you talking about her visits or the visits in DCFS?
I'm talking about DCFS generally.
Objection, speculation.
To my knowledge, they're not.
Okay. How about your visits? Have any of your visits ever been, the ones that you're monitoring,
Mm-hmm.
have they ever been recorded, either audio or video?
No.
Do you know whether there's a policy against that at DCFS?
I do not.
Do you know whether it would be illegal for a parent to record those monitored visits?
Objection, speculation. Illegal or
Illegal.
Illegal, okay.
Illegal?
Objection, speculation.
That's not something I have knowledge of.
Has anyone ever requested to you that they be allowed to record the visits?
Yes, Mr. Ball requested.
Is she the only person that has ever made that request to you?
I believe so.
Now, you denied Ms. Duval's request to record the visits, right?
Yes.
Okay, why is that?
To my knowledge, it's just not done.
Was that a decision that you made yourself?
I don't recall.
Do you recall whether you asked anybody, including your supervisor, whether Ms. Duval should be permitted to record her visits?
Objection, speculation.
At this point in time, I don't recall.
Did you have any fear of allowing Ms. Duval to record the visits?
I don't recall having fear.
Did you have any concerns whatsoever about Ms. Duval recording the visits?
Only from the standpoint, to my knowledge, it's not done.
Okay. How did you gain that understanding that it's not done?
I don't know. It's just my understanding of it.
But you, sitting here today, you don't recall whether you consulted with anybody, do you?
I don't recall.
Do you remember telling Ms. Duval she's not permitted to record?
I remember reading it.
Okay. And that decision, based on the deliver service log entry, it seems to me that your answer, you cannot record, was provided to her in that same monitored visit that she could not record. Isn't that correct?
Objection, vague and ambiguous.
I would need to look at the delivered service log.
Lena, would you find that for me? We'll return to that in a second.
Okay.
Isn't it true that when you are writing down a summary of your contacts with Ms. Duval during monitor visits, that you are to record only your observations and not your opinions?
Objection, vague and ambiguous. Assumes facts, not an evidence.
Can you give me an example or?
Well, I can show you what we'll mark as Exhibit 10. This is Procedural Guide 0400-503.05, Standards for Documenting Contacts, Bates number DCFS CRU 566 through 570. Let me direct your attention to page 3 of 14 in this exhibit. You see on the very bottom, would you mind reading that for me?
I'm sorry, which one?
Okay, well, let's start at the very top, and so we
Okay.
know what heading we're under.
Okay. Documenting face-to-face contact for an ER investigation.
Oh, okay, so this is ER.
Exactly.
Okay, but anyways, let's skip down to the very last item on the list, the very bottom. What does that say?
It says document only your observations, not opinions.
Okay. Is it your understanding that as a CSW, that obligation extended to all of your duties in terms of what you are to report?
Objection, speculation. Foundation assumes facts, not an evidence.
This is discussing an ER investigation.
I understand.
Um,
It's an analogous
a case-
situation.
Not necessarily.
All right.
Okay.
I'm sorry, I didn't mean to cut you off, but go ahead.
Okay. As a case-carrying CSW, my role is different. I'm not investigating the family.
Okay.
Okay.
But I'm asking you regarding your documenting of the monitored visitations.
Mhm.
Was that something that you were tasked with doing, meaning you were to document only your observations and not your opinions?
I'm tasked with writing a contact that reflects the overall gestalt of the visit,
And what do you mean by gestalt?
the overall picture.
Okay, and when you're talking about the overall picture, what is that? What might that include?
What happened, the child's response to what happened, the parents' response to what happened, and perhaps some guidance for future interactions.
Okay. As part of the monitored visitations,
Mhm.
were you also required to, were you supposed to interact with the parent or child as part of the monitored visitation?
As
Objection, vague
necessary.
and ambiguous.
That is necessary?
No, as necessary.
As necessary, okay.
Mhm.
And when you're talking about as necessary, what are some of the circumstances in which you might interact with a parent or child?
Objection calls for narrative.
I believe some of those circumstances are listed in the guide, is to ensure the safety and welfare of the child.
Okay. Was it part of your duties to ask, for example, Ms. Duval, her opinions about things that are going on in the case?
Objection, vague and ambiguous.
I need an example. I'm not
Okay,
sure
well,
what
let me
you're
ask you
talking
this.
about.
As part of your monitor visitation,
Mhm.
was it part of your duty to ask Ms. Duval why she was taking certain steps in her juvenile case?
Objection, vague and ambiguous.
Any steps?
Same objection, vague and ambiguous.
Can you give me an example?
Let me see this. Here's what I'll do. I'll make a list of, because I don't have it right handy right now.
Okay.
And we'll return after like a 5-minute bathroom break and
Sure.
we'll ask questions. But now you were monitoring visits for Miss Duval as part of efforts to reunify her with her son, or to provide reunification services. Isn't that correct?
That is correct.
Okay. As part of monitoring the visits, would it ever be proper to antagonize a parent during the visit?
Objection, vague and ambiguous as the term antagonize.
Well, I'm asking you. I mean, would it be appropriate under any circumstance to antagonize a parent?
Again, I would refer back to the situation. When you're supervising a visit, you are responsible for the health and well-being of that child.
Okay. Yeah. Yeah, that's actually a yes or no question, so let me ask you again. Would it be proper under any circumstance to antagonize a parent during a monitored visit?
Objection, vague and ambiguous as to the term antagonize.
Do you understand what antagonize means?
Well, it can mean different things.
Okay, let's go with your understanding of the word antagonize, and then we can decide whether we agree with that.
Antagonize perhaps is to make a parent upset
Okay.
during the visit.
All right. So with that understanding, then,
Mhm.
would it be appropriate to antagonize a parent during a monitor visit under any circumstance?
Objection,
Yes.
incomplete
Okay,
hypothetical.
under
For
what-
safety and welfare of the child.
Would you disagree with the statement that you had antagonized Ms. Duval during these monitor visitations?
Objection, vague and ambiguous. Speculation as to.
I'm sorry, can you, it's the phrasing that's confusing me a little bit.
Did you antagonize Ms. Duval during the monitor visitations?
Objection calls for speculation as to the plaintiff's frame of mind.
Not to my knowledge.
Now, you had a chance to, well, it was your job, actually, to observe the monitor visits, and including Ms. Duval's demeanor, isn't that correct?
Yes.
Okay. Do you recall whether Ms. Duval reacted negatively to you when you would ask her questions during these monitor visitations?
Objection, vague and ambiguous as to which visitation.
I need some kind of specific on questions
Okay, sure.
during visitation. Can you give me an
Sure.
example?
Do you recall any instance where Ms. Duval complained to you that she felt that you were biased and that you were reporting false facts in your notes for the monitored visits? Do you recall that?
Objection, foundation assumes facts on an evidence.
I seem to recall there is an entry where she told me she felt I was biased.
And we talked about that briefly last Thursday, didn't we?
I don't recall.
Okay. Now, during that visit, do you recall Ms. Duval's demeanor when she said that to you?
I would need to be refreshed on the visit.
Sure. But you don't have any independent recollection without looking into the documents?
I would need to be refreshed on the visit. There's many visits in there.
Okay. So you understand which specific incident I'm talking about, though, don't you?
I need to be refreshed on the visit.
All right, let's take a look at the contact date 6/17/2010 at the top of the page. Why don't you take a minute to review that entry?
Thank you. Yes, thank you.
Okay, what was Miss Duval's demeanor like when she spoke with you that day?
Well, first I would like to correct something. You
Sure.
were asking me about antagonizing a parent during a visit.
Right.
This is not during a visit. The visit is over. The child has gone home. And I'm speaking with Ms. Duval privately,
Now,
following a visit.
the private conversation after the visit, is that part of your job duties?
Yes.
Okay, under what category would that fall under?
I don't know what category.
Well, for example, the stuff that we talked about just up until now was the monitoring and visitations, right?
Yes.
So what might talking to Ms. Duval after a visit fall under in terms of your job duties?
Objection, vague and ambiguous.
It can be a wide variety of things. On this particular occasion, I asked her if she was pregnant.
So I guess the question is, why are you speaking with Ms. Duval at all after a visit?
Because that's part of offering services to a client.
Okay. And what service were you offering on this visit?
I believe we spoke about a variety of things, but I asked her about a pregnancy because this is an open court case.
Okay. Why is that significant?
Because we've already detained one child from her care.
And so the concern is that you may need to detain the second?
If she's pregnant, the court needs to know.
So the court needs to know whether Ms. Duval is pregnant because they may need to go back and get the second child, right?
Objection, speculation.
Any number of things could be put in place. That's only one possibility.
Every time that you would meet with Ms. Duval after a monitored visit, was that solely for the purpose of offering services to Ms. Duval?
It can be for a variety of reasons. I would need to look through everything and see the various reasons that I met with her.
Was Ms. Duval required to meet with you after the visits?
She could say no.
Okay. Was Ms. Duval required to answer any of your questions?
A client can always say no.
Would that have been a negative mark if Ms. Duval did not answer your questions after a monitored visit?
Objection, incomplete hypothetical, speculation, and vague and
Well,
ambiguous.
let me ask it this way. If Ms. Duval refused to interact with you after a monitored visit, or she refused to answer your questions, is that something that you would write down as part of your contact notes?
Yes.
Okay. And you would write it down because Ms. Duval is not being cooperative, isn't that correct?
Objection, speculation, incomplete hypothetical.
I would write the fact. Ms. Duval chose not to meet with me this date. Or Ms. Duval chose not to answer.
Because that would be used to show that Ms. Duval is not being cooperative with the investigation, isn't that right?
Objection, assumes facts not in evidence, incomplete hypothetical, speculation.
I'm not an investigator.
You are not an investigator?
On that case,
Okay.
I'm not an investigator.
Okay. During the time that you were working on Ms. Duval's case,
Mhm.
you're representing to me today that you were not taking on any investigative role?
I'm telling you my role was not that of an investigator. There's always ongoing reporting to the court in any case.
But it wasn't your job to determine whether, for example, Ms. Duval was intentionally did not fail to feed her child, for example.
Objection, vague and ambiguous, speculation, incomplete hypothetical.
When you say failed to feed her child, you're talking about the past.
Well, let me ask you this. Okay, we've got a juvenile petition. It sets forth allegations, right?
Yes.
Okay. Those allegations, was it your job duties at all at any time to investigate whether those allegations are true and correct?
Objection, vague and ambiguous. Speculation.
I'm a little bit confused.
Well,
Am I investigating
whether the facts
what
stated
happened prior? I'm confused.
yes,
Sorry.
whether the facts stated in the juvenile petition are true. Was that part of your investigation? Or were you tasked with investigating that at all?
Investigating.
Whether the,
Objection, vague and ambiguous.
whether the allegations in the petition are true.
Objection, vague and ambiguous.
I'm not the investigator in the case. I'm following
Thank
the
you.
case at this point.
Was Miss Duval? Now you were a sorry. What was your the title of your role during the time that you were working on Miss Duval's case?
Family maintenance and reunification.
Okay. And after Miss Duval's case, did you continue in that area, working in that area, family maintenance, family reunification?
Objection, vague and ambiguous as to time.
Well, okay. Let me ask you this: was Miss Duval's case the last one that you worked on, where you were working in family reunifications, family maintenance?
I would need to review the records.
Did you monitor visits after Miss Duval's case had ended in other cases?
I don't remember.
What is your after you moved on? Then you're not in family maintenance, family reunification anymore.
I'm in emergency response
When
at this
when
point.
did you get transferred?
Objection, asked and answered.
I don't have a date, and that's
Ballpark
my
would be fine.
Objection, asked and answered.
Are you unable to give me an estimate?
I'm not sure. I would prefer to give you an accurate date.
Well, it's not really about a question of preference. I just want a ballpark. Was it a year or two ago? Was it more than 5 years? How long? We're only talking about the last 5 years. Isn't that right? Miss Duval's case ended in 2010, right?
Mm-hmm.
Okay. 4 years have passed,
Okay.
and at some point in time, you no longer were working in family reunification, family maintenance, right?
Right.
Okay. What is your estimate of when that change happened?
The problem is I don't remember.
Okay, if you don't remember, that's fine. Was Miss Duval's case, just based on your experience, at DCFS, was it an unusual case for you?
Objection, vague and ambiguous.
Unusual in what way?
And unusual in the sense that it stood out from some of the other cases you've taken, that there are aspects of the case that were either strange or novel or unique.
Objection, vague and ambiguous.
Every case is unique. Every case is unique.
Okay. What about the outcome in Miss Duval's case? Was that something that stood out to you as unusual?
Objection, vague and ambiguous. Calls for speculation.
Unusual in what way?
Well, do you believe that the right result was reached in Miss Duval's case?
Objection, speculation.
I wasn't in court. I didn't hear the testimony. And I am not willing to speculate on the court's decision.
You spent a lot of time with Miss Duval, though, didn't you?
I monitored a lot of visits.
Months and months. In fact, out of 88 pages, your first contact begins, I think, on page somewhere in the 20s. So you spent a lot of time with Miss Duval monitoring her visits, isn't that true?
I spent about half an hour on most of the visits, I believe.
Did you form an opinion during these monitor visits that Miss Duval failed to feed her son in the past?
Objection, speculation.
Sorry, prior to November 3rd, 2009.
Objection calls for speculation.
I don't know. I mean, I don't know how to answer that. That's a confusing question to me. I was not investigating her past. I was working with her in the present.
Okay. So then let's talk about the present,
Mhm.
meaning present during the time that you were monitoring Ms. Duval's visitation.
Yes.
Did you form the opinion during the time that you monitored Ms. Duval's visitation that she was incapable of taking care of her child?
Objection, vague and ambiguous.
Incapable of taking care of her child is a very broad term.
Okay, incapable of properly taking care of her child such that DCFS involvement would not be necessary.
Objection, vague and ambiguous.
Again, taking care of her child is very broad.
Okay. You are a social worker tasked with, well, you're involved with parents that are accused of sometimes of abusing their children. Isn't that right?
Yes.
Okay. And DCFS doesn't become involved with a family unless there are serious concerns, right? With a family?
Open a case. We become involved with many families where there are no
Sure, let's
serious
talk about
concerns.
opening a case.
Okay. So do we open a case unless there's serious concerns? Yes, there will be concerns if
Okay.
we're opening a case.
And the concerns when we're talking about child abuse, suspected child abuse by a parent, we are also talking about concerns about whether a parent can properly parent their child. Isn't that true?
Objection, incomplete hypothetical.
Properly parent their child is a very broad term.
Well, let's give a proper, specific definition just for
Okay.
this line of questioning.
Thank you.
And the way I'm going to define proper is proper meaning that the parent is not abusing their child within the meaning of Welfare Institutions Code 300. Does that make sense to you?
Objection calls for legal conclusion.
So let's go through some types of abuse. There might be
Okay.
physical abuse, there might be emotional abuse, there might be sexual abuse, right?
Right.
Now, if a parent is physically abusing their child within the meaning of Welfare Institutions Code 300, that would be improper parenting, wouldn't it?
Yes.
Okay. And the same thing goes for sexual abuse and also emotional abuse.
Yes.
Okay. So that's what I'm trying to get at. When I say proper, I mean proper means it's outside of Welfare Institutions Code 300, what a parent is permitted to do with their child. Can we share that understanding?
Yes.
Okay. During the time that you monitored Ms. Duval's visitation, did you ever come to the opinion that Ms. Duval was incapable of properly caring for her child?
The case hinges on what happened to the child prior to the case being opened. Meaning, how did she care for the child before the child was removed from her care? I was not involved in that part of the case. I was involved with it after it was opened and moving forward.
Let me ask you this. You were tasked with providing family reunification services, right?
Yes.
Okay. Would you ever give reunification, would you ever reunify a parent with a child that they're not properly taken care of?
Objection, foundation assumes facts not in evidence. She cannot make the decision as to whether or not to
No.
reunify a child with
Well, I'm
its
asking
parent.
you, just based on your experience, would DCFS ever allow a person that they know is not properly caring for their child to reunify with that child?
Objection, assumes facts not in evidence. That's actually not even DCFS's decision to make. That's the juvenile court.
The court decides.
Okay. Recommendations. Let's just change the focus to the recommendations that DCFS might make. Okay?
Mhm.
Would reunification services be recommended for a parent that's not properly taking care of their child?
Objection, speculation.
Again, it's a very broad question. If a parent is not taking care of their child, would we recommend reunification? I believe we would likely recommend something else, but it's very speculative. It's not relevant to this
Here-
situation as I understand
Here,
it.
the court did order reunification services during the pendency of the juvenile case. Isn't that true?
You know, I'm not clear about that.
Well, that's why you were monitoring the visits, isn't it?
We were following the court's orders. I would need to see the minute order whether it said, were we providing FR services? I don't remember.
So now you're saying that you're not sure whether you were providing FR services to Ms. Duval?
What I'm saying is I'm not sure what the court ordered. I would need to see a minute order
Okay, but
reflecting it.
What services were you offering Ms. Duval if not FR services?
We were providing the services that the court ordered. I don't recall exactly what they ordered, but I would be happy to look at a minute order and see what they ordered.
You didn't bring the minute order, did you?
I don't have the minute order.
So at this point, unless you see that minute order, you can't tell me, sitting here today, whether you were providing family reunification services to Ms. Duval?
When we are providing visitation, that is part of family reunification. Exactly what the court ordered, I do not remember.
Okay. So when your understanding then was that you were providing family reunification services for Ms. Duval, whether that was court ordered or not?
We were providing the services the court ordered.
Including the monitoring of visitations, right?
Yes.
With the object of seeing whether you can reunify the parent with the child, right?
I'm unclear what you mean, seeing whether we can reunify the parent with the child.
Well, was the object to reunify the parent with the child?
The object is always to reunify the parent with the child.
Thank you. Okay, now as part of the object of reunifying the parent with the child, did you form an opinion whether Ms. Duval was a fit parent or not?
Objection calls for contention, calls for legal conclusion. Vague and ambiguous.
Again, this case was not decided on the period of time that I was monitoring her. This case was decided on
I'm not asking
before.
And again, I'm not asking about that. And I think what you're indirectly stating here is an objection based on relevance. But what I'm entitled to is an answer to the question. So if I can get the question I asked reread, please.
Question. Thank you. Now, as part of the object of reunifying the parent with the child, did you form an opinion whether Ms. Duval was a fit parent or not?
And same objections apply. Vague and ambiguous. Calls for contention, calls for legal conclusion.
I don't know how to answer your question.
Okay, why are you unable to answer my question?
Can I hear the question again? I'm finding your question very confusing. Could you
At the
phrase it
time-
another way?
At the time that you monitored Ms. Duval's visitation, did you form the opinion whether or not Ms. Duval was able to properly care for her child?
Same objection calls for legal contention in the
You're-
sense of that you defined properly care for the child as whether or not the allegations
That's
in the
fine.
petition were sustained. So that's
Go
why it's
ahead.
confusing.
Let's go ahead.
I'm sorry. The whole thing seems very convoluted to me, so I'm having a difficult time with it.
I'm not sure how much more simple I can make it for you, though. Do you understand when I'm asking you, did you form an opinion whether Ms. Duval was capable of properly caring for her child? What part of that don't you understand?
Objection, speculation, vague and ambiguous, calls for legal contention.
You're asking me to either to agree or disagree with the court.
No, I'm not. I'm asking you for your personal opinion. Okay? At the time you monitored Ms. Duval's visitations, did you form an opinion whether Ms. Duval was able to properly care for her child?
Same objection, speculation, contention, calls for legal conclusion.
And it's a yes or no question.
Properly care for her child is a very broad term.
No, again, we are going with a narrow definition of properly caring for her child, meaning proper is outside of Welfare Institutions Code 300. That's all I'm asking
But that's
about.
for a judge to decide.
That's still very vague. It's very broad. And there are many shades of gray in situations.
We're talking about Ms. Duval's situation.
Okay. I'm unable to give you a yes or a no.
Okay, is that because you're refusing to answer the yes or no?
Because I'm unable to decipher your question, and I can't
Okay,
give you an answer.
that's the thing I'm entitled to. Is what part of it don't you understand? How can I help you so that you are able to answer the question?
Can you rephrase it?
In what way? I mean, I can't. You've got to give me some guidance here.
It's your question. She doesn't understand the question as
I
you
don't
set
know.
forth, along with the definitions that you set forth. So ask if you know what you want, what information you want. Ask the question in a different way to obtain the information you want.
I'm entitled to an answer to my questions, and if it's a simple question, then it should be answered.
But
Did
it's
you
not a
form the
simple
opinion?
question.
Did you form the opinion during the time that you monitored Ms. Duval's visits that she was incapable of properly feeding her child?
Objection, vague and ambiguous as to the term incapable. Vague and ambiguous as to the term properly.
Incapable? You have a vague and ambiguous objection to incapable?
Yeah.
Do you understand the question?
No, I don't. And
Okay, what part don't you understand?
I don't understand.
Objection, argumentative, harassing.
I don't understand the question. It's very vague. It's very broad, and I don't understand it.
Okay.
I'm sorry.
You understand that Ms. Duval had her child seized from her because of allegations that she willfully and intentionally failed to feed her child, such that he failed to thrive. Do you have that understanding?
I understand that is why I was
Okay.
detained, yes.
And that was based on DCFS action, wasn't it?
Objection, vague and ambiguous. DCFS action.
DCFS removed the child, didn't they?
The child was detained from the mother, yes.
By DCFS.
Yes.
Okay, and when DCFS seizes a child or continues to detain a child, they should have good reasons, don't you agree?
Objection, vague and ambiguous as to good reasons.
Well, they should have some reason, right?
I believe
Objection, argumentative.
Go ahead.
Calls for contention.
I believe when children are detained, they're detained under the law. That would be the reason for the detention. It would be a legal
Now
reason.
that's very vague. The question I'm asking you is, shouldn't DCFS have reasons for continuing to detain a child?
Objection, vague and ambiguous, incomplete hypothetical, speculation.
Reasons.
Sure. Reasons supporting the continued detention of the child. For example, DCFS shouldn't arbitrarily be permitted to continue detaining a child, right? Would you agree with that?
The case is in court, so the case is going to be heard in court. The case is going to be decided in court. It's not decided by me.
It's not decided by DCFS, and it's not decided by
Right.
you. But that's not the question. The question
Okay.
is, when DCFS continues the detention of a child,
Mhm.
they should have some reason why they're doing that, right?
And I would expect that those reasons are provided to court, and court is
Okay.
making rulings on those reasons.
Right, and that's what I'm trying to get at. There should be
Okay.
reasons that support that, right? You agree with that?
Yes, yes,
Okay.
there's reasons that are provided to court, and court is
Right.
ruling one
and,
way or
and
another.
those reasons should be articulable, meaning that you should be able to state them, right?
Mhm.
Okay. Now, when you are providing reunification services, you're monitoring Ms. Duval's visits, right?
Yes,
And you're supposed to record everything, both the good and the bad. You're
Yes.
supposed to give a complete and accurate account of what you are observing, right?
yes.
Okay. And as those observations that you're recording are going to be used by other social workers downstream who are going to incorporate in their reports, right? That they present to the court.
Objection, speculation.
Some of it will be, some of it won't be. It's one piece that's reported to court,
Okay,
along
but-
with
but
many
some
other
of it
things.
would be, right?
Some of it would be, yes.
Okay. And it's your understanding that the accounts that you're creating of these monitor visits, they're going to be used by the social workers in their court reports. I agree that not all of them will be used, but some of them will be used. Some of them will be used to support the recommendations that DCFS makes concerning the dependency case. Isn't that true?
Objection, speculation.
There's a variety of evidence that's used.
Okay.
Some of the delivered service log may be presented to court along with other evidence, yes.
Okay. And so your understanding when you create these records of your contacts with Ms. Duval,
Mhm.
the monitor visits, you understood that some of what you are going to provide may be used to support recommendations that the DCFS is going to make.
I understand that it may be some of it may be presented to court.
And some of it may also be used for recommendations that DCFS may make regarding reunification between the mom and the child, right?
Objection, speculation.
You know, I'm a little uncertain about that.
Okay, why are you uncertain?
There's a variety of sources that are used, and there's a variety of evidence that's used. So you're giving me a very broad picture here, and
Well, didn't you tell us at the last visit that the monitor visits are the #1 indicator of whether there will be successful reunification?
Yes, I did say that.
Okay, so you understand then that part of monitoring these visits is to determine whether it would be appropriate for a parent to be reunified with their child.
That's not the reason for that statement.
Okay, what was...
The reason for that
What's the difference
statement
then?
is that when parents do not visit, they do not reunify. So a parent that visits is showing an interest in their child. It's not because the record of the monitored visitation determines whether they reunify or not.
Okay, so at the time that you monitor Ms. Duval's visitation then,
Mhm.
with the understanding that what you write there, in your contact notes, your observations of these reports may be used in court
Mhm.
reports downstream,
Mhm.
including recommendations DCFS is going to make. Did you form any opinion about whether it would be appropriate for Ms. Duval to reunify with her child?
My opinion is that the previous investigation and information from that piece was going to be primary in this case. This visitation is not primary in this particular case.
Why is that?
Because the case itself had to do with what happened to the child prior to being removed from mother. That's
how
the
how
crux
did you
of
gain
that
that
case.
understanding? That it... Sorry. I'll
Still
slow
talking.
down.
Okay.
How did you gain that understanding?
From looking at what the issues are.
So
The allegations are not that mother is starving or failing to feed the child while he's removed. The allegations are that she failed, I forget the exact wording, failed to feed the child prior to being removed.
Right, but the allegations concern, I understand,
Mhm.
incidents that had happened prior to the case, the juvenile case.
Prior to reunification services being...
Right.
Yes.
Now, are those facts the only operative facts that you consider when deciding whether a parent should be reunified with a child?
Objection, foundation assumes facts, not an evidence.
Because that seems to be what you're telling me, and correct me if I'm wrong.
No, objection, foundation assumes facts, not an evidence. Speculation.
I'm not deciding whether this child reunifies or not.
I understand that.
I'm not recommending whether this child reunifies or not.
Okay. The question, though, is you mentioned just now that the case turns on whether on what the truth it turns on what happened prior to DCFS involvement, the facts prior to DCFS involvement, right?
I would say primarily.
And that is that the only thing that we consider when we decide whether to provide whether to reunify the mom with a child? Are those the only facts that we consider?
Objection, speculation. Misstates testimony. She says that wasn't the only thing that is considered. That is just the primary thing
Well,
that's
let's
considered.
get the testimony from the witness.
Okay. I'm retestifying to the same things, that there are issues. The reason the child was removed from mother
Right.
are major issues in this situation. Secondarily to that are the things that happen after the child was removed.
Okay, so in order of priority then,
Mhm.
you're saying that whether or not the accusations leveled by DCFS in the juvenile petition, whether they are true or not, that's going to be the #1 issue to be decided in deciding whether Ms. Duval should be reunified with her child. And then secondarily, after that would be the counts of what has happened with Ms. Duval after DCFS involvement. Am I understanding you correctly?
I don't know if you are or not.
So let me just make it simple then, because it seems like you are refusing to tell me today that whether or not you formed an opinion regarding Ms. Duval's fitness as a parent, or her ability to properly parent her child, or to properly feed her child. You didn't form any of those opinions.
I can't respond to those questions. That's my problem.
Okay, and why not?
Because they're very vague and broad.
So how is DCFS to make a decision in terms of recommending that a parent be reunified with their child or not, if they can't even form an opinion about whether a parent is fit, whether they can properly feed a child, whether they can properly care for a child? How can DCFS make any recommendations without forming such an opinion?
Objection, speculation, argumentative.
Again, I'm not making a recommendation.
I understand that you are not making a
I'm not
recommendation.
making a recommendation.
You understand, though,
Report.
that you are part of the process in which the DCFS makes recommendations. You would agree with that statement, wouldn't you?
Yes.
Okay, great.
Mhm.
So then, since you're a part of that process, then I'm asking you, how can DCFS make a decision for something as important as reunification between a parent and child if they are unable to form an opinion about whether a parent can properly care for their child?
The recommendation is made on the totality of the information.
Great. Okay, so as part of your job duties, you also considered the totality of the circumstances, right?
Objection, misstates testimony. Foundation assumes facts, not an evidence.
Again, I'm not making a recommendation in this case.
Okay. I understand you're not making the recommendation.
Mhm.
You are creating records, though, that will be used by DCFS, somebody downstream,
Mhm.
who's going to use that to make recommendations. You understand that, right?
I am creating a record
Okay.
of visits and contacts and interactions that happened.
Right. And you understood that the reason why you were monitoring these visits was for family reunification purposes.
Yes.
Okay. So you understood that because you were in the family reunifications and you were creating these contact notes, at some point DCFS is going to weigh in on this issue of family reunification, right?
Yes.
Okay. So did you form an opinion then, one way or the other, regarding whether Ms. Duval should be reunified with her child?
Objection, vague and ambiguous.
We are back to the case revolves around issues that happened prior to detention. Do I know?
Please stop.
Okay.
Well, let her answer
Hold
her
on,
question.
please stop, because the thing with that is that you just told us that what happened prior to DCFS involvement was one component of that decision, right? Of the reunification issue, right?
It's a major component.
It's a
in
major
this
component.
individual case, in this case,
In this case, in this particular case.
I believe, yes.
Why is that?
Because it revolves around whether or not the child was properly cared for, fed, all of those issues prior to detention.
Okay. And why is that important? Why is that so important to the decision to be made regarding whether Ms. Duval should be reunified with her son?
Objection, vague and ambiguous.
In this particular case, the child is failure to thrive. He was highly underweight. He was globally delayed. So,
What does that have to do? What does that have to do with reunification?
the question is, how did he become that way? And what has changed since the child was detained that would prevent future similar problems, I guess.
Okay. So what you're telling me then is that whether or not Ms. Duval in the past, prior to DCFS involvement, whether she failed to feed her child,
Mm-hmm.
was going to be the #1 indicator on whether she should be reunified with her son?
Objection, speculation, misstates testimony.
I can't state that.
Okay. Isn't it true that a parent could be provided services, for example, how to properly parent a child, how to properly feed a child, such that they could be taught how to take care of a child, and the circumstances that brought about the failure to thrive could be remedied?
Objection, compound, incomplete hypothetical, speculation, vague and ambiguous.
Could you break that down for me a little bit?
Would you mind rereading my question? See if I can break it down for her.
Question, okay, isn't it true that a parent could be provided services, for example, on how to properly parent a child, how to properly feed a child, such that they could be taught how to take care of a child, and the circumstances that brought about the failure to thrive could be remedied?
Okay. How many failure to thrive cases had you handled prior to Ms. Duval's case?
I believe she was... Prior to this, I saw one as an intern.
What do you mean by intern?
I was an intern for the department prior to working for the department.
Paid or not paid?
Well,
By definition, it's probably
paid
not.
for schooling.
Was that also a case of environmental failure to thrive, if you recall?
It was a combination case.
Okay.
Intrinsic and extrinsic causes.
So, when you're saying intrinsic and what was the other word?
Extrinsic.
Extrinsic context, you mean that there is some biological concern with the child, right?
There was some biological and there was also environmental.
Okay.
There were both.
I don't need to know any of the particulars about this particular
No.
case. Certainly don't want any names.
No.
But do you recall whether any services were provided to the parent or parents in that case?
Prior to detention or post-detention?
Post-detention.
I was ER intern and I did not follow it post-detention.
Okay, then how about pre-detention?
No, there were not.
Okay. Ms. Duval wasn't provided any service before her son was taken either, right?
Objection, speculation.
If you know.
I would need to review the records. Are you...
Okay.
Yeah, that's a little complicated.
So let me ask you about this situation. We'll start with just the intrinsic and extrinsic causes.
Okay.
Are there circumstances... Well, hold on a second. Before we ask that question, how about after Ms. Duval's case? Did you handle any other failure to thrive cases afterwards?
I did have some, yes.
Okay, some meaning about approximately how many?
In ER, maybe 2 or 3.
Okay, and how about anything that you witnessed after ER?
No, I'm in ER right now.
Oh, you are in ER now.
Right.
Okay. Are services typically offered to parents that have children that are failing to thrive prior to detention?
Objection, speculation.
Depends on the circumstance.
Okay. Based on your experience, what are the types of services that have been offered in the past?
Objection calls for narrative.
In the particular situations that I've had, there were no pre-services offered.
The cases where that you've seen where there were no pre-services offered, did any of the parents bring their child to you? How would you learn of how would DCFS come to learn about the child's failure to thrive condition?
Objection, speculation.
We learn in various ways. I mean, some of them come to the hotline for that reason.
Parents themselves?
No, the referral goes to the hotline due to failure to thrive.
I guess
condition.
let me ask you this: of any of the failure to thrive cases that you've handled,
Mhm.
were any of them where the parent, for example, brought the child, said, "I don't know how to take care of this kid. He's not gaining weight."
No.
Okay.
No.
So the cases that you've seen, there were always some outside referral, reporting about the child's condition, right?
We-
Meaning not a parent.
We can't get involved without an outside referral. We always have a referral before we have a case.
Okay. Of the failure to thrive cases that you've handled, and I'm talking about all of them,
Mhm.
were there any where it was not elevated to a case?
Not to my knowledge, no.
Okay.
Sam, it's been like over an hour.
I'm sorry.
Can we take
Yeah.
a quick break.
Let's take a quick break, and then I'll be very efficient. I think I'll be able to wrap things up in another 15 minutes.
Thank you.
We're off the record at 11:33 a.m. So let me get you played.
46. Okay, here we go.
Download them and then it converts the file.
Sorry,
And the other incident I'm looking for, which she hopefully. Look at this. They even tabbed for us what was important. These are the records she produced for us.
They just, I have it up. Why don't you just tell me so I can just look for the word?
Yeah, $3.93. Best price.
You know, I lost my laptop adapter. I'm wondering where I left it at Atlantic Aviation.
Yeah.
At the time.
Well, 5 keystrokes.
Let's go talk.
Okay.
Wait,
so-
hold on. What was the other? I have it up. Just tell me the word and I'll look for it.
Gosh, scatterbrain right now.
Okay.
Yeah, we'll
Okay.
back to it.
Okay.
Goodbye.
We're back on the record at 11:44 a.m.
Okay. Before we resume the discussion that we were having just now, I wanted to revisit that issue about videotaping of the monitored visits. Again, it was your understanding that it's not permitted, right?
It's my understanding that we don't videotape anything.
Okay. I want you to take a look at exhibit number 3 and page 45 of 88 on the very bottom. The last entry, and then it moves on to the following page if you take a look at that. I'm mostly interested in just probably the final 10 lines of that entry.
The final what?
10 lines, maybe.
Okay. Okay.
Now that you've had a chance to review that entry, does that refresh your recollection regarding the monitored visit of February 18, 2010 between Ms. Duval and her son?
Is that the date on that visit?
Yeah, you can.
I didn't check the date.
I can verify if you'd like.
February 18th, yes.
Okay. Now, does that refresh your recollection regarding Ms. Duval requesting that the monitored visitations be videotaped?
Yes.
Do you recall now, based on your review of this entry, whether you consulted with, for example, your supervisor or anybody else at DCFS regarding Ms. Duval's request to videotape the visits?
Well, clearly at that moment she asked me and I said no.
So that was your decision?
Yes.
What was your reason for denying Ms. Duval's request?
Objection asked and answered.
I think I just said that to my knowledge, we do not videotape anything. Not interviews, not visits, not anything.
Are you aware of any policy that says that you're not permitted to?
I don't know.
Okay. Were you ever trained that you're not to allow that, the videotaping of visits?
I don't recall.
Subsequent to this interaction with Ms. Duval that we just mentioned,
Mm-hmm.
did you go back to find out from anybody else whether it would be impermissible for Ms. Duval to videotape her visits?
I don't recall.
What was your understanding of why Ms. Duval was requesting that the visit to be videotaped?
Objection, speculation.
She did not say.
Okay. Would you agree that if the videotapes were, if the visits were videotaped, that would lend itself to creating a more complete and accurate account of what had happened during the visit?
No.
Objection,
Why not?
incomplete hypothetical. Speculation.
I don't see how it would make a difference in that regard.
Okay. Do you think there would be any benefit at all to having the monitored visits videotaped?
Objection, incomplete hypothetical. Speculation, vague and ambiguous.
Well, at all is a very broad
Okay.
term. At all. I can't answer
If
at all.
I'm going to give you a hypothetical. I'm not going to give you a hypothetical. If Ms. Duval was not happy with your monitoring of her visits, isn't that
Mhm.
true? Okay.
Oh,
Objection,
wait.
speculation.
I'm not saying yes, she wasn't unhappy. I'm sorry. I was saying, that I'm hearing
Sure.
you. So
Well, let's get an answer to the question then.
say the question again, please.
Okay. Ms. Duval was not happy with your monitoring of her visits, isn't that true?
Objection, speculation.
I was not aware of her being unhappy with my monitoring.
Well,
No.
okay.
I was not aware of her being unhappy with my monitoring.
Was Ms. Duval unhappy about any aspect of your monitoring of her visits?
Objection, speculation.
I am not aware of her being unhappy with my monitoring.
Okay, she was unhappy with your recording of what happened, what transpired in the visits, right?
Objection, speculation.
I believe she stated that I lied in the court report.
So Ms. Duval did not feel that you were being truthful and accurate in your reporting of the monitored visits. Isn't that true?
Objection, speculation.
I don't know what she was referring to when she said I lied. She was not specific, as I recall.
In a circumstance where a parent is complaining about the truthfulness or the accuracy of what is going on in a monitored visit, don't you think it would be reasonable for a parent to ask that the visits be recorded?
Objection, argumentative, speculation. Incomplete hypothetical, assumes facts.
Parents have many options if they're not happy with their monitored visitation.
Okay, I'm going to return now back. Okay, so if a parent's not happy and you said that they have options, what are the options that they have?
They can speak to the court. They can speak to my supervisor. They can speak to my supervisor's supervisor. There's a chain of command.
Did you yourself ever raise a concern that perhaps you are not the most appropriate monitor for Ms. Duval's visits?
No.
Objection. Objection, foundation assumes facts, not in evidence.
Okay, I want to return to this, the issue of the failure to thrive cases that you've handled to date. And one of the questions I have is, at the last deposition you mentioned that Ms. Duval's son made dramatic gains while in his father's exclusive care during the pendency proceedings, right?
Yes.
Okay. When you say dramatic improvements, how did you measure that?
By observation and by reports from outside agencies.
Were you specifically trained to detect what is dramatic and what is not dramatic?
Specifically trained. No, I was not specifically trained to determine what was dramatic or what was not
So
dramatic.
how did you establish a baseline, at the time you were evaluating Raffalina's son, whether or not the gains he was making was dramatic or whether it was expected?
Baseline was where he was when I first met him to where he was when the case ended.
And you're not a medical doctor, right?
I am not.
So, in terms of the dramatic improvement in the child, at that time you didn't have a basis for establishing some sort of a baseline in terms of a child that was sorry. Let me scratch that entire line. Okay. Some failure to thrive cases, as you mentioned earlier, are mixed cases. They're organic, non-organic causes.
Yes.
Some cases, it's maybe the parent is, intentionally not feeding a child. That's another case, potential case, right?
Potentially.
Okay. And if we're talking about the latter case, where a parent is not feeding the child intentionally, and the child is removed from that parent's care and placed elsewhere, how would you determine whether the child's improvement is going to be dramatic, or whether it's the normal development of the child, of normal development of a sickly child, for example?
Objection, vague and ambiguous.
It's really a
Compound.
broad question.
When you said that there were dramatic gains made by Raffalina's son, what basis did you have to make that opinion?
Objection, misstates testimony and assumes facts, not in evidence, in that that was a description that she gave when asked about her opinion in the deposition. It's my understanding that she never used the term dramatic in any of her documents. that
Well, what were
went
the
to
words you
juvenile court.
used?
In the documents to juvenile court?
Well, at her last deposition, as I recall, she said that the child had made dramatic gains.
Because
Right.
Mr. McMillan asked her what her opinion was.
Right.
But this
and
was
now,
on
now,
something-
I'm, now I'm probing her opinion right now.
Right.
So
Okay.
go ahead.
Just
And
to
that's-
clarify, that's what you're asking, is about her to clarify an opinion she made in deposition and not in the court
All right, you've
reports.
stated your objection.
Okay. My opinion on the dramatic gains is based on my observation of where the child was when I met him and where he was at the end of the case as a social worker, not
Sure.
as a doctor.
So the dramatic gains that you are seeing, you can't tell me today whether that dramatic gain was due to the fact that the child was removed and placed in Mr. Mill's care. You can't establish that cause, right?
Objection argumentative, calls for contention.
There were many factors in play while the child made developmental gains. Being in Mr. Mill's care was one of those factors. One factor.
Okay. So what are some other factors?
Other factors include improved nutrition. Other factors included regular medical care and advice that was followed, and also working with therapists to help the child make gains and following through with what the therapist advised.
To your knowledge, was an MMPI ever performed on Ms. Duval during the time you were involved with Ms. Duval's case?
Not to my knowledge.
Okay. How about a 7:30 evaluation?
What about it?
I'm asking the same question.
Was it?
Was there a 7:30 evaluation done on Ms. Duval during the pendency of the juvenile case, to your knowledge?
Not to my knowledge, no.
Okay. How about a psychologist? Did any psychologist ever examine Ms. Duval during the pendency of her juvenile case?
Objection speculation.
If you know.
The only thing I know of is the upfront assessment. Whether that was a psychologist, I don't recall.
Okay. All right, let me just wrap this up here. Earlier, you testified that the word observe and assess are essentially synonymous to you, right?
Objection misstates testimony.
Within the context of your job duties as as a monitor for Ms. Duval's visitation.
Off the top of my head, that may be what I said. I don't remember.
Okay. But assessment definitely does not involve rendering an opinion about anything you're observing, right?
Assessment will, in some assessment situations, it will lead to an opinion,
Mm-hmm.
of course.
Okay. And were you responsible for recording those opinions
Objection vague and ambiguous. As
in
to-
the delivered service logs?
Objection vague and ambiguous as to opinion.
Can you give me an example?
Well, you just said that sometimes these assessments lead to an opinion, right?
Yes.
Right. So I'm asking you whether those assessments that lead to an opinion, whether those opinions would be included in the service logs.
And I'm asking, can you give me an example of an opinion?
How about this? I'll give you an opinion of what I think is an opinion, and then maybe we can through that. But
Can you give me an opinion from the delivered service
Yes,
log
I'm going
so
to do that
I
right now.
I could address it? Thank you.
all right, how about 11/5/2009? We're going to turn again to exhibit number 3. Oh, sorry, this is not it. Okay. Turning to page 29 of 88. Do you see the word smothered there?
Yes.
What does the word smother mean to you?
In this context,
Sure.
it was just completely covering the child with hugs and kisses without regard to his response. It's overwhelming, smothering him in an overwhelming manner.
And this, when you say smother in this
Mhm.
service log entry, was that a fact that you observed, or was that an opinion about what you were observing?
That's how it appeared to me as I observed it.
So it was appropriate for you to write smother,
I believe so.
and that was an observation.
It was my observation.
You also spent a lot of time notating that Ms. Duval had shaking hands, right? In your service log entries, do you recall that?
I documented her shaking hands as I observed them.
Okay. What was the significance of Ms. Duval shaking hands to you?
They were happening.
Right.
They were something that I observed.
You also observed that her hands would shake more often in certain scenarios.
Yes.
And not so much in others, right?
Yes.
Okay, and what circumstances did you see her hands shaking more?
When she touched her child.
When she would interact with her child, right?
Not necessarily interact. When she would touch her
Okay.
child.
And what did that mean to you?
I didn't know what to think of it.
Well, you wrote in some of these logs that it appeared that it was stressful for Miss Duval to care for her child, right?
That is how it appeared. She told me, that is based on her words, she told me that her hands shake worse when she's under stress.
Mm-hmm.
So therefore, when her hands shake worse when touching her child, I'm assuming that she's under stress in that situation.
Okay,
Based
so,
on what she told me previously.
so was that an observation or was that an opinion?
It's an observation based on what I have been told by Ms. Duval.
You also wrote as part of the civil rights investigation file that you said that if a 7:30 evaluation was ordered, then the handshaking of Ms. Duval becomes relevant. Do you recall making that statement?
Yes.
Okay, now how does the handshaking become relevant if there's a 7:30 evaluation?
Because it's a relevant feature to be explored in a 7:30 evaluation.
Why?
Because it's happening and it's an unusual presentation.
Ms. Duval told you the reason why her hands shake, though, right?
She told me that her hands shake and they shake more when she's under stress.
And what else did she tell you about her tremors?
That her brother and her father have them as well, and that they never, something to the fact that it didn't bother her.
But she did tell you that she was going to see a doctor, right?
She told me she was going to have it checked out.
Did you follow up with that doctor?
I was never given any information on that.
You didn't ask for it, though, did you?
I didn't ask for it. I wasn't given any information on it, on whether she went or didn't go.
Okay. During the pendency of the juvenile case, at any time, did you tell Ms. Duval that she was like a cow for wanting to breastfeed her child?
Absolutely not.
Did you tell anybody else that?
Absolutely not.
Anything even similar to that?
Nothing.
Okay. How about the statement that by the time you or DCFS is through with Ms. Duval, that she would not have the energy to get out of bed? Did you say anything like that to Ms. Duval?
Never.
Okay, how about to anybody else?
Never.
Are you aware of anybody at DCFS saying something
Never.
to that effect?
No.
Okay, I just have one final question.
Mm-hmm.
Ms. Duval, during the time that you were monitoring her visits, complained about you, felt that you were not being fair to her, that you're inaccurately reporting facts, right?
Objection, speculation.
In your court reports, do you remember this?
I don't believe her words were inaccurately reporting facts. No.
She said you lied, right?
She said something to that effect, yes.
That you were not being truthful and accurate in your reports.
I don't believe it was
essentially,
that.
right? I'm not asking for verbatim. I'm saying,
Right.
you know, we have some common understanding, right, about what I'm talking about.
She said that I lied.
That you lied. Okay.
Right.
You continued monitoring visits with Miss Duval, right?
I was her social worker.
Okay, and you would not allow her to videotape the visits, right?
No.
Ms. Duval asked for a different monitor, including Narissa Ennis, right?
Yes.
Okay, and you guys denied that request too, right?
Yes.
Okay. Now, sometime you learned in 2010 that Ms. Duval had complained that her civil rights had been violated, right?
Yes.
And Michelle Hochstein wrote you a letter that said that you are essentially under investigation and that you should not do anything that would appear to be a retaliation against Ms. Duval for filing a complaint, right?
I think she sent an email.
It was an email? Okay. You don't recall whether you received any letter on letterhead from her?
At the end, in the final
Okay.
result, I received a letter on letterhead.
But you did at some point receive a letter from Michelle Hochstein or some notification that you were under investigation, right?
Yes.
Okay. Why didn't you ask to be removed and have a different monitor monitor Ms. Duval's visits?
I believe at some point I did stop monitoring the visits, and it was probably around that time.
Okay. Did you stop monitoring those visits because of the issues that I just provided to you? Meaning, the civil rights investigation, meaning Ms. Duval complaining about the accuracy of your reports. Was that the reason why you stopped monitoring the visits?
I believe it had to do with once the civil rights violation was filed. At some point after that, I stopped monitoring visits, yes.
So, last question I got for you. Sorry,
Yes.
This is really the last one. Why wasn't that reported to the court that there was a civil rights investigation that concluded that Ms. Duval's rights have been violated based in part on your conduct?
Objection, foundation, assumes facts not in evidence.
Didn't occur to me.
Okay, this is questions. That's all the questions I've got. You want to take a quick break before we switch?
Yeah.
Or? Sure.
This is the end of media number 1 in the deposition of Victoria Sheele, Volume 2. We're off the mark at 12:07 p.m. We are back on the record at 1:28 p.m. This being of media number 2 in the continuing deposition of Victoria Sheele, Volume 2.
Ms. Sheele, my name is Richard Prager. I am one of Ms. Duval's attorneys.
Mm-hmm.
Let me take a moment and hand your attorney a document, which will mark as exhibit number 11.
Okay.
Please hand your client. Thanks. Please take a moment and review exhibit number 11.
Sure.
And let me know when you're done reviewing it.
Yes.
Thank you. Have you ever seen exhibit number 11 before?
I don't recall.
That would just be today's deposition notice. You understand you're testifying here because you've been requested to sit for your deposition, correct?
Yes.
Thank you. Now, in preparing for your deposition today, did you review any documents?
Yes.
Was it the stack of documents you gave our office?
That Desiree gave your office, yes.
Yes, okay. And you reviewed all those documents in preparing for your deposition today?
Yes.
And these are the same documents you reviewed in preparing for your deposition last week?
Yes.
Are there any documents that you reviewed that are not part of the stack that your attorney gave us today?
No.
Are there any computer records that you reviewed, strike that, are there any computer records that you reviewed in preparing for either of your depositions?
No.
So everything you looked at, we have before us in the stack, correct?
Yes.
Perfect. Thank you. All right, let me draw your attention to the civil rights investigation regarding Ms. Duval's case. You're aware of the fact that Ms. Duval filed civil rights complaints against the county and county personnel for the county's conduct during the investigation for her son, correct?
Yes.
When did you first learn about Ms. Duval's civil rights complaints?
When I was notified by Ms. Hochstein.
And how were you first notified by Ms. Hochstein of the investigation?
I believe it was email.
And that went to your work email?
Yes.
Do you recall what the email said?
I know that it notified me that I was subject of an investigation, and I believe it said to call her or contact her to set up a time to meet with her.
At that point in time, how long had you been employed by the County of Los Angeles?
I don't exactly recall when I got the email. My best guess is a year and a half, 18 months.
Thank you. And just so we're clear, when you say your best guess, you mean your best estimate?
Yes.
You understand no one wants you to guess here today.
Okay.
Let's be clear about something.
Okay.
If I ask you any question
Mm-hmm.
and you don't have a recollection of whatever it is you're being asked, please indicate you don't know. Can we agree to that?
Yes.
If I ask you a question that you may be able to estimate information, but you haven't got a precise recollection, I'm entitled to a recollection. Is that clear?
Okay. That's clear.
So a common illustration question could be like this. If I were to ask you how long did it take you from leaving your residence today, assuming you did, to drive to this deposition, you could probably estimate for me the amount of time it took to arrive here today, correct?
Yes.
But if I asked you to estimate how long it took me to arrive here, you'd have no way of knowing that, correct?
Correct.
That would be a guess on your part.
Yes.
So we want you to estimate but not guess. Are we clear on that?
Yes.
And you'll help us out with that.
Yes.
Perfect.
And if you could tell me when she sent the notice, I could tell you how long I've been with the department at that point.
2010.
Oh, I know it was 2010, but what month?
You can estimate for me because I don't have the email right in front of me. I think I have a good idea of the month, but you're free to estimate. So in 2010, what was your anniversary?
October.
Okay. And October would have been 2 years?
2 years.
Were you employed before you went to work for the County of Los Angeles about 2 years prior to the civil rights investigation being opened?
No, I was in school,
And what type of school were you in?
graduate school,
For an LCSW?
for a CSW. I'm sorry, for a MSW.
And how long were you in that program?
2 years.
Did you go full-time?
Yes, I did.
And did you pay for school yourself, or were you on scholarship?
I was on the stipend program.
What is
Through-
this?
You agree to work for the department for at least 2 years in return for a stipend, which pays for your schooling.
Does it pay for living expenses?
Yes. Well, small amount for living expenses.
Do you recall what the total stipend paid to you over those 2 years was?
$18,500 per year.
And after your second year, you're free to quit the department if you choose to.
And not owe the money back, yes. You can quit at any time, but
You'd owe them the $18,500 per year for 2 years.
yes.
Before you spent those 2 years obtaining your MSW, were you employed?
No.
Let me phrase that question to make sure we're clear. I don't know if you worked inside the house or not, but I'm asking, were you employed outside the home for remuneration?
I was not employed.
At that time, what did you do?
I was a student.
A student for what?
I received a bachelor's degree in sociology.
At this time, ma'am, how old are you?
Objection. Calls for privacy. It's not relevant.
I'm going to ask her questions about her education and work-life experience. So we can we can just step backward through time, or I can just do it by, hopefully faster, by asking general age categories. But
Well, you can ask her about her education and her work experience, but I'm going to ask you not to answer your age because it's not relevant.
when are you last gainfully employed for remuneration outside the county of Los Angeles?
1997.
And what did you do at that time?
I was in sales and management in the temporary help industry.
You said temporary help?
Mm-hmm.
Yes?
Yes.
And I think you were told last time, but if you do answer questions with an inaudible answer, we have to prompt you to give a verbal response.
Sure.
So the court reporter can take down your appropriate response. She's not allowed to interpret a negative versus a positive So please don't feel we're being rude.
Okay.
We're just making sure we have the record clear. Otherwise, she'll beat us with that machine like a samurai warrior. Okay, so 1997, you were in outside sales, is that right? I'm sorry, temporary help sales. Is that what you said?
Yes.
And what does that term mean to you?
That means I solicited business for a temporary help company,
What kind of temporary help were you talking about?
clerical.
Was it health?
Was it what?
Was it in the health field?
No.
So
Clerical.
It wasn't nursing.
No.
And any part of your clerical business involve hospitals or healthcare?
If there was any hospital involvement, it would only be in the office. It would not be, we didn't have medical people, no.
That was 1997.
I believe so.
Thank you. When did you start that work?
You know what? 97 might be the wrong date, now that I'm going backwards.
That's why I would just ask. I was going to use your age and just do
Yeah.
it by groupings, but
I spent 10 years in that industry. I'm going to say from maybe 82 to 92.
okay. So in 1992, let me just ask this. Is it correct that you spent 4 consecutive years in education to obtain both your baccalaureate degree and your master's degree?
No, that's not correct. It took me 9 years.
Okay, so now we have to break it apart and work through it that way. In what years did you attend college or university for your baccalaureate degree?
I graduated in 06. It took me 7 years, so what's that?
So approximately 1999 you began?
Probably.
And what school did you attend?
I graduated from University of Laverne.
Where is the University of Laverne?
Laverne, California.
Is that by Pasadena?
It's further east,
By about how much time?
half hour.
Thank you. Did you work while you were attending school as a student?
No.
Is there a reason why it took you 7 years to complete your baccalaureate degree?
It
And I'm
was.
going to object to the extent that it asks for private information. So if there's any sort of like private personal reason, it would ask you not to respond.
Okay.
But if it was just, a decision you make to take longer, then it's whatever.
I was doing other things concurrently.
Well, I appreciate that, but privacy, as you know, is an absolute. So I'd want an offering if there's something, for example, if she was disabled, if she was hospitalized, if she was undergoing treatment, that's one thing. If she was a mother staying home with children, that's a different thing. I don't think that really would invoke her privacy rights. I don't want to know how many kids she has, things like that. But if she's working part-time, if she's a part-time student, I think I'd be entitled to that. So, with regard to the 7 years, you were doing other things. Can you give us a broad category of what other things you were doing?
I'm going to object if those other things are personal or private.
And they are. They are personal and private.
So then don't answer.
The difficulty we have is we don't know what the basis obviously is. So, do you guys want to take a moment and confer, off the record, and then see if there's a way to bridge this quickly? We don't spend a lot of time doing this, but I want to find out her basic background. So,
Well, it's my understanding that you're trying to figure out like what other employment she had,
Right.
or whether she had any internships or something like that.
her medical background,
And so-
any medical training she has, her past work experience, so forth and so on. So, for example, if she was a stay-at-home mom working her way through school, that's one thing. If she was working in the same industry through school, that's fine. I don't know why this information is confidential or privileged, but I defer to you right now since you're asserting it, and I'm suggesting perhaps we can take a moment and you can make an offering to save some time. Otherwise, I'll be tweezing this out for a long time, and we'll have to probably go for a longer session today than I was hoping for.
That's fine. So let's just go off the record.
Let's go off the record.
and-
We're off the record at 1:41 p.m. We're back on the record at 1:45 p.m.
Thank you. We've had a conversation off the record, I understand from your attorney, that there were some personal, just a matter of choice it sounds like, and there were some internships you're working on. So with regard to the internships, just what were the general natures of the internships, the fields?
I did one school year, which is 9 months, with a group home, so an internship in a group home.
Anything else in your internships?
During graduate school, I did a couple of different ones. One was Drug and Alcohol Treatment Center, and then the second one was with DCFS.
And we just skipped, because before you were, it sounds like, unless I'm misunderstanding, the internship occurred during the 7 years of your college, and then it sounds like you skipped to your graduate education. Am I incorrect about that?
No, yes, you are correct about that. The year with the group home was during my bachelor's.
Okay. Are there any other internships during your baccalaureate program?
No.
So, if I understand correctly, you're now estimating your employment with the temporary help organization ended in 1992, give or take.
Mm-hmm.
Yes?
I believe so, yes.
And your baccalaureate program began in 1999, correct?
Something's wrong with the numbers, I don't know.
Sure. That's what I'm trying to understand. This is
Right.
let me repeat what I've understood your testimony to be, and correct me if I'm wrong.
Mm-hmm.
You testified that you worked in the employment industry between 82 and 92. You began your baccalaureate program in 1999 and finished in 2006.
I believe that's correct, yes.
Okay, those dates are all correct.
I think so.
So there's a 7-year gap, approximately, between 1992 when you ended your employment and 1999 when you began college. What did you do during the 7-year gap?
I wish I had my resume with me. I don't know. There's something wrong with the dates.
Well, I'm just trying to understand your history, so help me.
Okay.
What's wrong with the dates?
There shouldn't be a 7-year gap, is what's wrong with it.
Okay. Is it possible, let's just be clear, do you have a good recollection that you began your baccalaureate degree in 1999?
No. I think that's when I began.
Okay. Are you confident you ended your work at the temporary sales company in 1992?
No. There's where the issue is.
So it may be that you ended your temporary sales work around, say, 1997, 98?
It could have been later. Yeah.
But you're convinced that your work for pay had ended by the time you enrolled in college?
Yes. Yes.
Can you estimate how many years your work for pay ended before you enrolled in college?
Possibly. Possibly 2.
Okay. That's your estimate?
That's my estimate.
And during that period of time?
I had family commitments.
Okay. And I was just going to ask the question, so you didn't work during that period of time?
I did not.
Neither on a non-paid, like internship basis, or a paid basis?
No.
Now we have you attending your baccalaureate program from 99 to 2006. When did you enroll in your master's program?
Fall of 96.
Is it fair to say that you went directly from your baccalaureate program directly into your master's program?
I graduated in December or January of 2006, and then began in the fall. Yes.
And I'm sorry, you began in the fall of that same year.
Fall of 2006.
And it's correct, it took 2 years to finish your master's degree.
Yes.
And then you went to work for the county, correct?
Yes.
And you've been there ever since?
Yes.
I don't know your age, which is why I was asking. So if we had you working in temporary sales starting in 1997, was there a job that you held for pay before 1997?
Objection with state's testimony.
Yeah, I was not employed in the temporary help industry in 97.
I know. I'm asking, was there a job that you had before you began work in the temporary help business in 1997?
Yes, I was an administrative assistant.
Okay. For what years were you administrative assistant?
A period of about 8 years prior to going into the temporary help industry.
And for whom were you administrative assistant during the 8-year period of time?
I worked for an engineering firm called C.F. Braun, B-R-A-U-N, and Company in Alhambra.
Do you know if they're still in operation today?
I don't know.
And just so I'm clear, is it a civil engineering firm, mechanical engineering firm? What kind of firm is it?
They were involved with refineries.
Have we now covered your work experience, say taking you up until the period of time? Well, let me just ask this question. Let me withdraw that and ask. You graduated high school?
Yes.
Have we now covered all of your employment for pay between the time you graduated high school until you began this administrative assistant position?
No, I also worked as a secretary in a law firm.
For how many years?
Real estate, investment, trust type law. Maybe 3 years, 2 or 3.
And from there you went into the administrative position?
Yes.
So we've now covered all your employment?
Yes.
Is there any other education you've had we've not covered? For example, any certificates, credentials of any type?
I did learn, this is funny, key punching long time ago, probably right out of high school.
When there were key punches?
Yeah, when there were key punches, long time ago, and I worked for a short time for a bank doing that.
And when did you work for this bank?
Again, it was out of high school. I don't remember the year. It's been a while.
Okay. Any other certificates or credentials other than being a key punch operator or whatever you're certified at?
No.
As part of your job, you're not required to have any particular specialized certificates?
Specialized certificates,
Yes,
such
ma'am.
as?
Any kind of endorsements or special training? Or, for example, when you mentioned that when you were employed by the county, you went to work, I'm sorry, you went to the academy first, correct?
Yes.
When you graduated the academy, did they give you a plaque or a certificate saying you had completed their training?
I don't recall if they gave us certificates. It shows up in the computer that you've completed this, that. You've completed Core Academy.
Okay. You said Core Academy?
Core Academy is what it's called, yes.
And when you describe this, and this in your gesture, it kind of makes me think that some folks might be trained in other areas where some other individuals may not get trained. Is that a fair statement?
I believe Core Academy, everyone is trained the same.
Got it. So beyond Core Academy, are there any specialized areas of expertise people get trained to, is what I'm trying to understand.
When I went to ER, I received specialized ER training.
Okay. Was there a certificate for that training?
I don't remember if there's a certificate or not.
And to your knowledge, are you now designated as an employee that was trained to operate in the ER unit?
Yes.
Are there any other designations such as that you can share with me?
We always have opportunities to take individualized trainings. I don't know that those designate you as anything special. They're just different trainings you could take.
Got it. Did you had to finish your ER training though before you went for that unit, right?
It was concurrent with,
You worked while you were being trained?
yes.
So, and I'm sorry, that question could be made better. You were working in the ER department while you were being trained in ER protocols?
Yes.
And how long were you trained for?
I believe the ER specialized training was about, I want to guess, estimate 5 days.
Okay. And thank you. You're not guessing, you're estimating
Estimating.
based on your recollection.
Right.
Right. If you don't know, indicate you don't remember. Have you ever been placed on leave by the department for any reason?
No.
Okay. Drawing your attention back to 2010,
Yes.
when you received this email, you believe, advising you that a civil rights investigation had been opened because Ms. Duval had filed a complaint.
Yes.
What was your understanding at that time of what Ms. Duval was complaining about?
Speculation?
You understand we're asking for your understanding. At the moment you're first notified, there's a civil rights
Right.
investigation.
And I do not recall if it just said a civil rights investigation or if it listed, I think it just said civil rights investigation.
Do you mind just slowing down a little bit after you ask the question, just to give me a second to
Sure.
object if I need to?
Sure.
Thank you.
So, you received this email at work, correct?
Yes.
Do you recall where you were at work, for example, sitting at your computer, when you received this email?
I would have been sitting at my computer.
Do you recall your first thoughts when you opened this email?
I don't recall my thoughts. I recall being surprised.
Okay. What were you surprised about?
That there was a complaint for civil rights violations. Or that there was an investigation. Whatever it said, it surprised me.
At that point in time, about how many families do you think you had been working with for the approximate 2 years you were with the department?
I would estimate perhaps 20.
Over the 2 years that you'd been in the department, about 20 families?
Families, most likely, yes.
Okay. How about a total client population, if you want to call it that? How many people had you had contact with as clients in the department over that 2-year period of time?
That's difficult to estimate.
You're free to do the following. You can say over 50, over 100, less than 1,000, whatever range you can put on it.
Okay, so if there's 20 families, my estimate would be 60, would have to be probably, if we're counting, well, what are we counting? Are we counting parents, children, the total, all the people in the family?
Yes, ma'am.
Okay, 60 or more.
Okay. And the reason is, I realize that minor children couldn't file a complaint against a social worker, but any other person in the system is free to file a complaint against a social worker, correct?
Correct.
Okay. So, you know where this question is going. Over the 2-year period prior to learning of Ms. Duval's complaint, you had never had a civil rights complaint filed against you?
No,
That would be correct. You had no complaints against you before this?
I had no complaints against me.
Okay. Did you even know that there was a complaint mechanism for clients at that time?
Yes.
Were you aware of any of your coworkers having a complaint filed against them prior to receiving notification that you were the subject of a complaint?
I'm sorry, I didn't catch that.
Sure. Can we get the question back, Madam Reporter?
Question, were you aware of any coworkers having a complaint filed against them prior to receiving notification that you were the subject of a complaint?
I don't recall.
None that you do recall.
No.
So when you opened the email and you were surprised, do you recall more precisely what you were surprised about? For example, the fact that you were now the subject of a complaint, or that it was Ms. Duval? What were you surprised about?
I was surprised that I was the subject of a complaint, yes.
Because at that moment in time, in your mind, you felt you had done nothing wrong to warrant a civil rights complaint. Is that right?
Yes, I had no idea.
And is it your personal goal to try and treat all the clients that you deal with fairly?
Of course, yes.
And you would never outwardly commit any discriminatory act against any client, correct?
No,
That would be correct.
that would be correct. I would not.
As part of your training in the Core Academy, were you trained about the client's civil rights?
Yes.
What were you trained?
In a variety of things. That clients have, obviously, have rights, that they have, we're trained when we go to a home to ask permission to enter. They have civil rights in how to raise their children.
I'm going to make a belated objection that it calls for a narrative and vague and ambiguous.
Did you understand my question?
It's a very large topic, yes.
Well, and that's the way it goes. And then we go
Yeah.
smaller and smaller and smaller to get to where we're heading. Okay, so along that vein, with regard to the civil rights of the clients, do you
Yes.
have a greater understanding of what guarantees they have under the law?
Objection calls for a narrative and vague and ambiguous.
She can answer the question yes or no, actually.
A greater understanding than
Yes.
what?
Than what we just started with. We had a much broader discussion, right? And now we're limiting our conversation to move forward. And what I'm asking you is, do you recall any more particular topics that you were trained on in the academy regarding what civil rights the clients have that are guaranteed by the law?
Well, they're, again, this is sort of broad, but they are guaranteed equal access. They are guaranteed the right to be treated equally to anyone else. They have a right to not be discriminated on the basis of race, creed, color, and a variety of other things. Those are the things that come to mind right away.
Okay, basically you just gave us two categories. One is equal access, and the
Mhm.
second is non-discrimination, correct?
I wouldn't know how to categorize them. To me, they all sort of fit under that umbrella of treating people equally and fairly.
Okay. In your mind, does equal treatment, strike that, withdraw it. In your mind, is equal treatment the same as non-discrimination?
No.
How are they different?
Well, someone may need accommodations to access equal treatment.
Such as?
Objection calls for narrative.
Do you understand the question?
Yes, if you're in a wheelchair and you're going to have visitation in my office, I need to make sure that you can access the office and access the visitation room.
So that may take some affirmative step on your part to guarantee equal access to, in this case, your wheelchair example, the disabled person who's been invited to your office.
Yes.
And to your knowledge, has the department trained you to provide those services to disabled people?
Train me to provide services to disabled people?
Let me be clear.
Thank you.
I'm taking your illustration
Mm-hmm.
of a wheelchair user who needs to come see you, okay?
Yes.
And you've expressed as your previous response that you may have to take affirmative steps to guarantee a wheelchair user gets access to your office, correct?
Yes.
Okay. So I'm asking, for example, did the department train you on what to do with a wheelchair user that may call you and say, I'm coming to your office, I'm in a wheelchair, I need accommodations?
I don't recall a specific training that says if someone calls me in a wheelchair, do A, B, C, D. There is a generalized training. There's general training that if people need an accommodation, which a person in a wheelchair clearly would need an accommodation, then we are to make an accommodation. I also would need to know before the person came to the office that they're in a wheelchair so that I could make an accommodation.
And how would you confirm that?
Well, I don't ask every person I talk to if they are in a wheelchair. I would expect that they're going to tell me, I'm in a wheelchair, I'm coming to your office.
A moment ago you testified that you would need to know they're in a wheelchair.
Mm-hmm.
I'm not sure if I understood your testimony correctly. Are you suggesting that you'd want to confirm that when a wheelchair user calls you, you confirm they're in a wheelchair? Or are you simply stating that the client has to inform you of what their needs are before they arrive?
The client would have to inform me. Otherwise, how could I know?
Okay. So once you are informed of a client who has a special request for assistance
Mm-hmm.
based on disability, are you trained to do something next?
Yes.
What are you trained to do?
Objection calls for narrative. And incomplete hypothetical.
Is the question unclear to you?
So what am I trained to do? There is not a specific, again, not a specific training that says if client says X, do ABC. It is a general understanding that if the client has a disability, that you explore what needs to be done to accommodate them.
Okay. Have you ever heard of the terms interactive process before?
No, I have not.
You've not been trained in that.
I'm not familiar with the term.
Is there any guidelines, samples regarding what the department is willing to do to accommodate people and what they're not willing to do to accommodate people?
Objection calls for narrative, speculation, and vague and ambiguous.
Do you understand the question?
Could you repeat?
Absolutely.
Thank you.
We're talking, let's just stay with wheelchair users for a minute,
Okay.
since that's where we started. Somebody might say you're on the second story of a building.
Mm-hmm.
Maybe there's no elevator in that building. You have to see me somewhere else because I can't get to your office. Do you see what I'm saying?
Yes.
Okay. Are there any guidelines the department may have provided to you in your training on how to understand a client's needs and what you could agree to and what you can't agree to?
Objection, incomplete hypothetical, speculation. But you can answer.
Let me stop you. Do you understand the question?
Yes.
Perfect. Please answer it.
I do not recall.
Okay. And I understand that you're saying there's basically a generalized training
Mm-hmm.
on how to accommodate a person who self-identifies as being disabled, and I'm trying to get a better understanding over how you are trained. Is that clear?
Yes.
Is there anything else you can tell me in that regard about how you are trained?
Objection calls for narrative.
No.
To your knowledge, is there a person in your organization that you would speak to about a client's request for services?
The first person I would speak to is my supervisor.
In the last 24 months, I don't know particulars,
Mm-hmm.
Have you discussed disabled accommodations with your supervisor for any reason, on behalf of any client?
In the past 2 years, I have not.
Okay. And you would agree that disabilities includes both physical disabilities, such as being in a wheelchair, and mental disabilities, correct?
Objection calls for a legal conclusion, speculation.
Do you understand the question?
We're talking about that people can have physical disabilities as well as, did you say mental or emotional?
I said mental.
Mental disabilities. Yes, people can have both.
And they can have emotional disabilities as well.
Yes.
And do you believe the department has an obligation to provide services for persons suffering emotional disabilities?
Objection, speculation.
We have an obligation.
Calls for legal conclusion.
We
Yes.
provide services to everyone.
Got it. Do you have, let's be clear about what services we're talking about. Thank
Okay.
you. Do you believe the department has an obligation to accommodate people that are disabled secondary to an emotional disability?
Objection, incomplete hypothetical, speculation, and vague and ambiguous. And it calls for a legal conclusion.
I'm asking your knowledge.
I would need to review policy.
You don't recall sitting here today? You don't
Pardon?
recall sitting here today?
What do you mean I don't recall sitting here today? Oh, just I don't recall in general. Sorry. I got very concrete there with you for a moment. Yes, I recall sitting here, and I don't recall off the top of my head, yes.
Right, and just to be clear with the way you answered the question, when you answered you have to go review policy, I'm simply asking, you may have been trained, you may not have been trained, you just simply don't recall sitting here right now.
That's correct.
Okay, and that would also be true of people suffering from mental disabilities as well, correct?
Yes.
And by way of your experience or training, if you can share with us, what type of emotional disabilities would you be referring to?
Objection calls for a narrative, seeks a legal conclusion, and also seeks expert opinion.
You can answer the question if you understand.
It's not something I have dealt with, so I really can't answer.
Okay, about mental disabilities. What type of mental disabilities have you dealt with?
Objection calls for narrative, incomplete hypothetical, speculation,
Do you understand the question?
and vague and ambiguous.
Are you asking me what kind of mental health problems my clients have that I've worked with?
I'm asking you to describe, in the disabled context, any individuals that tell you they're suffering a mental disability that
Mhm.
requires accommodations.
Same objection calls for narrative, legal conclusion, incomplete hypothetical, and speculation.
I have never had a client request an accommodation for a mental health disability.
Okay. So you have had clients, however, request accommodations for physical disabilities.
Objection, foundation, assumes facts.
I've actually never had one that requested an accommodation that I can recall.
Okay. So, for example, you've never actually had a wheelchair user contact you and say, I can't get into your building.
No, I've not.
Have you ever had anyone who's disabled request any different room to accommodate any type of physical disability at all?
No.
And that'd be true for allergies as well?
I have never had that, no.
Okay, so you've never had a client contact you and say that they have allergies and they cannot appear at a certain location because they're reacting to the room because of their allergies?
No.
And if a client did come to you and say, I have allergies, I am reacting to this location, I'm requesting a change, what would your position be?
Objection, incomplete hypothetical, speculation, and vague and ambiguous.
I would discuss it with my supervisor,
Okay.
what could be done.
And do you have any understanding of what the accommodations could be for that disabled person?
Objection, speculation, incomplete hypothetical, vague and ambiguous.
Since I haven't dealt with it, I've never explored it.
Okay. So you have no idea of what even is available, if anything, to the person making the request?
Objection, incomplete hypothetical, speculation, vague and ambiguous.
Again, I've never dealt with it, so I've never had to make the request or inquire.
Got it. I understand that.
Mhm.
But you also went through training, right?
Yes.
And as part of your training, you must have discussed what you should do if a disabled person contacts you and requests accommodations, right?
Yes.
And you've already made mention to You may have to go back and review some of your policies, correct?
Yes.
So I'm simply asking, as you sit here right now, as part of your training, for example, did you cover any type of accommodations you could offer to a disabled person if it was requested?
I don't recall.
It may have happened, it may not have happened, you simply don't recall.
I don't recall.
All right. Drawing your attention back to the email when you first were notified of the open civil rights investigation.
Yes.
You saw the email. I think we've covered you weren't clear at that time about the basis of the civil rights complaint, correct?
That's how I remember it, yes.
Okay. Did you have some reaction to receiving the email about the civil rights complaint?
Objection asked and answered.
As I said, I was surprised.
Okay, I'm sorry. Was there some action you took next, for example, to discuss it with a supervisor or colleague?
I told my supervisor.
What'd you tell her? I'm sorry, was it him or her?
Her.
Okay. And what was her name at that time?
Karen
Karen what?
Vance. V-A-N-C-E.
Thank you. What did you tell Ms. Vance at that moment in time?
I told her I just received this notice.
Did you forward her a copy of it?
I don't remember.
Did you say anything else to her?
I don't remember.
Do you recall if she had a response to you or for you, if anything?
I don't recall. It's been a long time.
I understand. Okay. Now, at some point in time, did you make contact with the investigator?
Yes.
And do you recall the investigator's name?
Michelle Hochstein.
Which is Hochstein. So, when you first made contact, other than this email, with Ms. Hochstein, do you recall how you made contact?
I don't recall. I think she may have asked me to call. I don't recall if she asked for a call or an email, but I'm thinking it was a phone call.
Okay. To the best of your recollection, the first time you actually communicated with Ms. Hochstein was on the telephone.
I believe so.
Do you recall when this telephone conversation took place?
No, I don't.
Do you recall if it was in, say, within 2 months of receiving the email?
Oh, I responded to her promptly.
And in your mind, what does promptly mean?
That day, the next day, I don't recall what day it was, so if it was on Friday, Monday, Tuesday.
Do you recall that conversation?
No,
Do you recall anything about the conversation?
no.
Do you recall if Ms. Hochstein explained to you what a civil rights investigation entails?
I don't recall.
Do you recall if she advised you what Ms. Duval's complaints were at that time?
I don't recall.
Was there any action arranged during this telephone call? For example, having an in-face meeting within a week?
I believe I set an appointment to meet with her.
Anything else that occurred during this telephone call that you recall? Strike that. Was there anything else during this telephone conversation that occurred that you've not told us about at this time, which you do recall?
I don't recall anything else about that phone conversation.
Did you in fact then meet Ms. Hochstein about a week later?
I did meet with her. I don't recall the time frame.
So you couldn't say if it was a month or a week?
It was not a month. It was relatively soon. A week, 10 days, I don't know.
Okay. You had your first meeting within 10 days of receiving this email. Do you recall where the meeting took place?
It was at her office.
Where is her office?
It was at Chateau Place, but I'm not sure the address.
Is Chateau Place an office maintained by the Department of Strike that. Is the Chateau location you're referring to maintained by the Department of Child or Children and Family Services?
Yes.
So to your knowledge, the building you were meeting Ms. Hochstein in was a building operated by your department?
Yes. I believe so.
Okay. Can you describe what happened during this meeting?
She had a number of sheets. They had questions at the top, and she asked me the questions and she wrote answers.
How did you feel at that moment in time?
It was just a strange experience.
Were you angry that Ms. Duval complained about you?
No,
Were you shocked that she complained about you?
I was shocked, yeah.
Why were you shocked?
Because I would never knowingly discriminate against anyone. I believe in civil rights for people. I support civil rights for people. I wouldn't want someone in my family to be discriminated against, nor would I want to discriminate against someone else. So yes, I was just surprised. Yeah.
So what I hear you saying is it's an important
value for me.
Thank you. Value is
Is
where
what
I was
I'm
looking
saying.
for you.
Yes.
So this was an important value for you, and you would not intentionally breach this value with regard to your job or anything else.
Not in regard to my job, not in regard to anyone at any time.
Okay. During this meeting, did you learn the basis of Ms. Duval's complaints against you?
Yes, yes.
And if you recall, what is your understanding of what her complaints against you were at that moment in time?
They were, as I recall off the top of my head, age, national origin, political affiliation, marital status, disability. I believe there was one more.
Okay.
Seems like there were six. I don't know.
I'm sure we'll cover as part of the reports we're going to be going over in a minute.
Okay.
As a result of reviewing, I'll strike that, did you have a chance to actually review Ms. Duval's complaints during this meeting?
All I saw during this meeting was the little written part at the top of Ms. Hochstein's pages.
Do you know if she wrote them or someone else wrote them?
Objection, speculation?
I don't know.
I'm just asking for your
I
knowledge.
don't know.
Did Ms. Hochstein tell you she wrote them?
I don't remember.
Now, I realize there was a wide variety of complaints by Ms. Duval.
Yes.
Do you recall if you were notified at that time if there were specific allegations of any discrimination that you were involved in?
It was my understanding that they were all questions for me. That's how I understood it at the time.
And at that moment in time, did you also believe other social workers were complained about by Ms. Duval, or was it just you?
You know, I don't remember that part.
As part of this interview, were you asked to give a statement to Ms. Hochstein?
Yes.
Did you give a statement?
Yes.
Did you swear out your statement under the penalty of perjury?
Yes.
Did Ms. Hochstein explain to you what the penalty of perjury meant prior to signing your own declaration under the penalty of perjury?
I don't remember.
Do you have an understanding of what it means to sign under the penalty of perjury?
I have an understanding of it, yes.
What is your understanding?
That what is said needs to be the truth. It cannot be a lie or something you know to be a lie.
Okay. As far as your understanding, does the penalty of perjury also implicate anything regarding the omission of information?
I don't know.
What?
You guys didn't feel that? I didn't know it was a... Oh, okay.
Oh, like earthquake?
The room was shaking, but I don't know if it was a plane or if it was a... I was in Depot once where there was a light fixture above us and the whole room began to sway and everything. So.
Does everyone go under the desk?
I don't know. We just keep going. Okay, so basically at that moment in time, you gave Ms. Hochstein your view of Ms. Duval's complaints, correct?
I gave my responses to the complaints that were read to me, yes.
Okay. Did anything else happen during that meeting?
I don't remember anything else.
Did Ms. Hochstein ask you to provide her any information?
Oh, yes, she did.
What information?
She wanted a variety of documents.
Do you recall any of the documents she desired?
Not off the top of my head.
Do you recall the general categories of documents? For example, what the topics of the documents would have been about?
I don't remember.
Okay. Did you have a follow-up meeting with Ms. Hochstein?
She emailed me later some questions, and I responded by email. I did not meet with her again.
Now, at some point in time, the investigation concluded, correct?
Yes.
To your knowledge, other than your initial meeting with Ms. Hochstein, did you ever meet Ms. Hochstein again from the period of time after you ended your meeting with her initially and the time you were notified of her conclusions regarding Ms. Duval's civil rights case?
Did I meet with her in person, face-to-face?
Yes, ma'am.
No, I did not.
During that same period of time, did you speak to her over the telephone?
Yes, I did.
On how many occasions?
I don't remember.
More than 5?
I don't remember.
Okay, and if you don't remember, you can say you don't remember, but I'm free to test your memory. Was it
Okay.
more than 3 times?
Well, I don't remember. In terms of independent memory, I don't remember, no.
Are there any events you recall, for example, giving her policy A on one occasion, policy B on a separate occasion?
I sent her several policies by fax.
Okay. As a result of your faxes, did she ever telephone you?
I don't remember.
So you're unable to give us any estimate whatsoever of how many telephones you had with Ms. Hochstein other than this initial phone call?
We spoke. I don't remember how many times.
I understand. You just can't estimate, for example, was over 3 times, over 5 times.
I don't know.
Was it less than 10 times?
I would estimate less than 10, yes.
Would you estimate it's less than 5 phone calls?
I don't know.
Okay. Making it less than 8, would that be of any value?
I don't know.
Okay. So less than 10
Sorry.
phone calls.
Yes.
I understand. We're just trying to test what you recall and what you don't recall. How many policies did you provide Ms. Hochstein, to your knowledge?
I don't recall.
After you provided her this fax information as part of the phone calls you do remember having with her, did you call her to explain your understanding of the policies you had just sent her?
I don't remember.
Well, we know a few telephone calls occurred after she requested information from you, correct?
Correct.
Can you tell me what you recall of these phone calls?
I don't remember. I just don't remember them.
Okay, so you couldn't, there's not a single fact that you could tell us as you sit here today regarding these multiple phone calls?
No.
All you remember is they occurred, that's all you know?
Yes.
Now, you're aware of the fact there were other social workers under investigation as part of Ms. Duval's allegations, correct?
That's what I understand, yes.
At any point in time, after you first were notified of Ms. Duval's complaint and the civil rights investigation, did you speak to any other persons who were complained about by Ms. Duval?
Yes.
Okay. Whom?
I spoke with Candace Nelson
Anyone else?
and Susan Pender.
With regard to Candace Nelson, when was the first time you spoke to her about the Duval complaint?
I don't know.
It was after your phone call with Ms. Hochstein?
I don't recall.
It was certainly after you got the email from Ms. Hochstein.
Certainly, yes.
But you couldn't say if it was before or after, for example, your phone call with Ms. Hochstein?
No.
Could you say if it was before or after your personal interview with Ms. Hochstein?
I believe before.
What occurred during the telephone call?
All I recall is just, wow, I'm shocked.
Okay. And what did Ms. Nelson say to you, if anything?
You know, I believe she had also received an email, and she was also shocked. And that was about the extent of it.
Did you deny to her that you had done anything wrong?
I don't know.
At that time, do you know if Ms. Nelson denied to you that she had done anything wrong?
I don't recall.
How about Ms. Pender? When did you first speak to her about Ms. Duval's complaint?
It would have been around the same time.
Do you recall what occurred during that telephone conversation?
No.
I'm sorry.
It's just sort of the same. It's like, I'm shocked.
To your knowledge, at this moment in time, when you received notification of the complaint, were you all working in the same office?
No.
Do you recall where you were working?
I was working in Lakewood.
And do you recall where Ms. Pender was working?
Objection, speculation.
I'm only asking to your knowledge. If you don't.
Possibly Metro North. But
And what community is Metro North in?
what community?
Yeah. Van Nuys, Burbank. Where is it located?
I believe it's in LA.
LA proper, like downtown LA?
I believe so.
Okay. And I believe we asked that for Ms. Pender. Let me ask for Ms. Nelson.
Also out of Metro North.
Sir, to your knowledge, this period of time, Ms. Nelson and Pender were working in the same office.
I believe so.
For the period of time when you first made contact with Ms. Nelson until you learned about the results of the civil rights investigation, did you ever discuss with her Ms. Duval's complaint?
No, I don't believe so.
So just one occasion.
Yes.
And the same question for Ms. Pender.
Yes.
So to the best of your recollection, you only had one conversation with Ms. Nelson about Ms. Duval's complaint.
That's all I recall.
And it's also true you only had one conversation, to the best of your recollection, with Ms. Pender regarding Ms. Duval's complaint.
That's all I recall, yes.
Okay. Now we've covered Ms. Hochstein,
Yes.
and we've talked about your supervisor for a moment. Other than the one conversation you've described for us regarding Ms. Duval's complaint, have you otherwise spoken to your supervisor regarding Ms. Duval's complaint? Want to rephrase that? I'll rephrase it.
Please.
You mentioned that you spoke to Ms. Vance upon learning about the civil rights complaint, correct?
Yes.
And that was in person?
Yes.
And I'm asking, other than that in-person conversation, for the period of time between when you got the email from Ms. Hochstein until you learned about the conclusion of the civil rights investigation, did you speak to any other co-workers about Ms. Duval's complaint?
I don't recall speaking to any other coworkers about it, no.
Can we take a break? It's been about 15 minutes.
Yeah.
Okay, thanks.
We're off the record at 2:33 p.m. We're back on the record at 2:46 p.m.
You ready to continue?
Mm-hmm.
So, I think we just covered it. Let's make sure I understand it correctly. With regards to any supervisor you may have had, you only spoke to one supervisor on one occasion regarding this incident for the period of time between the day you received the email from Ms. Hochstein until you received notification that there was a conclusion for Ms. Duval's civil rights complaint. Is that accurate?
I spoke to my supervisor, Karen Vance. I also spoke to Sonia Contreras, who is not my supervisor.
Okay. Let's get those two other individuals. I'm sorry, the first person again was what?
My supervisor is Karen Vance.
Karen Vance. So we
That's
have
who I
her.
spoke to. And I did speak to Sonia Contreras, who was my ARA.
To make sure we're on the same page, what's an ARA?
Assistant Regional Administrator?
Would this be your supervisor?
Yes.
And are there any other intermediary supervisors between Ms. Vance and Ms. Contreras?
Not that I recall, no.
I'm sorry, I think I just changed her name. What's her last name again?
Contreras.
I got it right? Okay.
Yeah.
So please explain to me what conversation took place with Ms. Contreras.
She asked to speak with me. I went up to speak with her. She told me not to send Ms. Hochstein any further faxes or phone calls. And I said, okay.
When you said up, does that mean physically she was on a floor
She's on
above
a
you?
second floor or third floor, more than the second floor.
Do you have a permanent office?
Permanent?
Yes, ma'am. Do you have a desk somewhere?
Yes.
And is it my understanding at this time that your office was in Lakewood and Ms. Contreras' office was on the third floor above you?
Yes.
So when you got word that Ms. Contreras wanted to speak with you, how was that conveyed to you?
I believe Karen told me.
Oh, on the phone, in person?
Miss Vance told me in person.
In person.
That's what I recall.
And this would
I
be
think
on
so.
some... Sorry.
I think that's how it happened.
Got it. This would be on some other occasion, not the day in question where you've already testified about telling Ms. Vance about the email.
I'm sorry, can you repeat that?
Certainly. We know that you spoke to Ms. Vance when you got the email, correct?
Yes.
And what I'm asking now is, based on the way you've described the events, is it correct that Ms. Vance approached you on some other day after you spoke to her the day you got the email and said, Ms. Contreras wants to speak to you about this email?
Yes.
Do you recall when this conversation with Ms. Vance took place?
I do not.
Was it within 30 days of your initial phone call with Ms. Vance about the email?
Phone call?
Strike
With-
that. Excuse me, thank you. Was it within 30 days of your conversation with Ms. Vance regarding the email?
That would be my estimate.
Okay. Did Ms. Vance say anything else to you about Ms. Contreras requesting this meeting?
Not that I recall.
Did she give you an advice about what to tell Ms. Contreras or not tell Ms. Contreras?
No.
Did she volunteer whether or not she'd ever seen a civil rights investigation for one of her social workers before?
I don't recall.
Do you recall ever asking her that question?
No.
You don't recall.
I don't recall.
Okay, so when you arrived at Ms. Contreras' office, was that the same day that Ms. Vance asked you to see Ms. Contreras or some later time?
Same day.
So can you explain how the conversation started?
I don't remember.
Do you recall who began speaking first?
No.
Do you recall what she told you during the conversation?
As I stated earlier, she told me don't send more email or don't send more faxes and don't make more phone calls.
Did Ms. Contreras inquire about who Ms. Duval is?
I don't recall.
Do you recall if Ms. Contreras asked anything about the underlying civil rights complaint?
I don't recall.
Do you have any understanding regarding who employs Ms. Hochstein?
No.
Do you know? You don't know who she works for?
No.
Do you know if she works for example, the Affirmative Action Unit of the County of Los Angeles?
I do not know who she works for.
Do you know if she works for the Department of Child and Family Services?
No, I don't.
Do you have any understanding under her authority to investigate you as a social worker?
Objection, vague and ambiguous speculation.
Do you understand the question?
No.
You were being investigated by Ms. Hochstein, right?
Yes.
For a civil rights violation, right?
Yes.
I'm sorry, an alleged civil rights violation at the time, right?
Right.
So when you spoke to Ms. Hochstein, did you understand what authority she had to compel you to answer her questions?
I understood that she had authority to conduct an investigation under what umbrella? Is that what we're talking about?
Yes, ma'am.
I don't know. I don't remember. Maybe it was said. I don't remember. I don't understand, no.
So Ms. Hochstein may have explained to you this information during the investigation. You simply don't recall right now.
That is correct.
When you were in Ms. Contreras' office, how did it strike you that she directed you not to provide any further faxes to Ms. Hochstein?
Objection, vague and ambiguous.
Do you understand the question? I'll rephrase it if you don't.
Yes. How did it strike me?
Yes, ma'am.
I remember my response, which was, okay.
Now, obviously, I know there's a video camera, but you shrugged,
Mhm.
so we don't want to include your body as an exhibit.
Okay.
You had a kind of reaction like, okay, like no big deal, right?
Yes.
But this was a civil rights investigation, right?
Yes.
Which is a big deal to you.
Yes.
So, and the civil rights investigator asked you for information, right?
Yes, she did.
And you promised to give it to her, right?
Yes, I did.
Because you want to make sure the investigation was thorough, correct?
Yes.
Because you were confident that when all the information was discovered, you would be cleared of any wrongdoing, right?
Yes.
Objection, speculation.
So your supervisor is telling you not to provide any information to a civil rights investigator investigating a client's complaint about multiple facets of discrimination, right?
No.
That's incorrect?
Yes.
What's incorrect about it?
Any information.
Okay. So you're saying that she said, don't call or fax. Is that what she said, Ms. Hochstein?
Don't call or fax.
Yeah.
She said, don't fax any more policy. And it's too many phone calls, I believe. Something of that nature.
Okay.
So,
There's too many phone calls business.
mhm.
I'm not sure I understand it. What was your understanding at the time she said that?
Objection, speculation.
I'm asking for your understanding, nobody else's.
My understanding was not to call her further.
Ms. Hochstein,
Yes.
did you ask Ms. Contreras why she would tell you that?
I don't recall.
How many times had you been in the RA's office before this occasion?
A few times.
Is that 2?
Oh, more than 2.
4?
I don't know.
Okay. Well, let's estimate things again.
I know.
Was it more than 5, less than 10? Can you help me out there?
I'll estimate 10.
Okay. It's true, however, it was intimidating to have your RAR, strike that. It was intimidating to have your let's try that. It was intimidating to have your ARA at this moment in time discussing this civil rights investigation with you, right?
Objection, foundation assumes facts.
You can answer the question.
Can you restate that?
Yeah. Was it intimidating being in the strike that. I keep getting the wrong vowel. Was it intimidating being in the ARA's office discussing Ms. Duval's civil rights complaint?
No, it was not.
It felt natural to you?
It did not feel intimidating.
Okay. When Ms. Contreras was speaking to you, what was her tone like?
It was a normal tone.
She didn't appear upset in any way to you?
No.
Did you ever ask her during this conversation if she had been involved in other civil rights investigations?
I do not recall asking her.
Did you feel it was your place to ask her that?
My place?
Yes, ma'am. Did you feel comfortable asking the ARA if she had been involved in other civil rights investigations during this conversation.
I don't recall asking her that question.
I understand. But did you feel comfortable enough to ask her that question if it struck you during the conversation?
Objection, assumes facts, incomplete hypothetical, speculation.
I feel very comfortable with ARA Contreras.
Okay. Are you suggesting that you feel she's supportive of you?
Objection, speculation.
In my experience, she is supportive of social workers in general.
And what does that statement mean to you?
I'm not afraid of her.
And do you think that she supports social workers doing their job on behalf of the county?
Objection, speculation.
Yes, I believe she does.
Okay. So you weren't concerned that the meeting you were involved in, let me rephrase that and ask it this way. At that moment in time, you weren't concerned you were, so to speak, in trouble because the ARA was asking to speak with you?
No.
And generally speaking, of the possibly as many as 10 times that you were in the RA's office before, what was the general subject matter you were there to discuss?
Cases.
Client cases.
Client cases.
Okay. We have this one conversation with Ms. Contreras. Were there any other forms of communication at all between you and Ms. Contreras regarding this civil rights investigation?
Not that I recall.
No other emails from her?
I do not recall any emails from her.
No other telephone calls?
I don't recall telephone calls from her.
No other in-person meetings with her to discuss this civil rights investigation?
I don't remember.
At any time, was there any administrator that spoke to you about this civil rights investigator other than the one time with Ms. Vance we've spoken about and the one time with Ms. Contreras we've spoken about?
I'm sorry, can you say that again?
Sure. Can you read the question back, Madam Reporter, please?
Question, at any time, was there any administrator that spoke to you about this civil rights investigator, other than the one time with Ms. Vance we've spoken about, and other than the one time with Ms. Contreras we've spoken about?
I don't believe there were any other administrators involved, no.
Okay. And I'm talking about from the date you first got an email advising you of the opening of the investigation until the time you learned it was completely closed. Other than Ms. Contreras and Ms. Vance, there were no other superiors you spoke to regarding this civil rights investigation.
Actually, when you said that, I do recall one other situation, and that is when I began working in ER, and I did inform that ARA in ER that I had a civil rights investigation.
Who was that individual?
Tim Varvay.
How do you spell his last name?
V-A-R-V-A-I-S.
Now, at the time you gave this information to Mr. Varvay, did I get that correct?
Varvay.
Perfect. When you spoke to Mr. Varvay, to your knowledge, was the investigation closed or was it still open?
I believe it was open.
Do you have any recollection with regard to the month and year of this conversation with Mr. Varvay?
The year was 2010. The month, I don't know.
Okay. Do you recall any reaction he had to you disclosing this information to him?
No, I don't.
Okay, we now have Mr. Varvay, Ms. Vance, Ms. Contreras. The same question regarding any other supervisors you've spoken to regarding the civil rights investigation from the day you learned it was open until the day you learned it was completely closed that you've not told us about.
I also informed the ER supervisor that I went to work with.
What is his or her name?
It's a man. His name is Adrian Gonzalez.
Do you know if that's A-D-R?
I-A-N.
Thank you. And did you say Gonzalez?
Gonzalez.
with a Z at the end?
I believe so.
Thank you. Okay. So the same question, we now have Mr. Gonzalez, Mr. Varve, Ms. Vance, and Ms. Contreras. Anybody else we missed?
I believe at some point here I stopped monitoring Ms. Duval's visits, and Anika took over monitoring those visits. I'm not sure if she was told the reason, but it's possible that she was.
And to your knowledge, is there any writing that would basically take you off the Duval matter and reassign it to someone else?
You mean, was it reassigned to someone else?
Well, you
Unclear.
mentioned that you stopped managing your visitation, correct?
I stopped monitoring visitation.
Thank you. You stopped monitoring the Duval case and visitation, correct?
Yes.
And I'm asking, was there some document generated
No.
saying? Let me get the question
Okay,
up.
go ahead.
Thanks. Was there some document generated to your knowledge that said you will no longer monitor Ms. Duval and her visits and somebody else will be taking your place?
No.
With regard to Mr. Gonzalez, you mentioned you disclosed the investigation. Was there a response on his part?
I don't recall his response.
Do you recall anything else about this conversation you've not told us about?
I do recall Ms. Vance suggested I take a union rep with me, and I declined.
A union rep to which meeting?
To the meeting with Ms. Hochstein.
And did Ms. Vance make that suggestion during the conversation we've already spoken about?
It may have been another conversation, I don't recall.
So it's possible you had more than 2 conversations with Ms. Vance regarding this case?
It's possible.
Okay.
I don't recall if she told me when I first told her, or she told me on another occasion. I don't recall.
I understand. Thank you for helping us with that information. So
Mhm.
basically you're saying that you think there was at least 3 different contacts by Ms. Vance with you regarding the Duval civil rights investigation.
I think so, yes.
The 3rd time when she suggested that you take a union rep, there was more conversation than just that, right?
I don't know if that was the second conversation or a third conversation.
Okay. Do you recall if anything else was discussed during that meeting whenever it occurred?
I don't recall.
And I'm sorry, you said that you did not take a union rep with you?
I did not,
Do you know why Ms. Vance suggested you should take a union rep?
because Ms. Vance is active in the union.
I see.
Yeah.
Okay. Are you active in the union?
No.
All right. So you had this meeting, we've already talked about it, and you did not bring a union rep, correct?
Correct.
We now have these 4 individuals, Ms. Vance, Ms. Contreras, Varveas, and Mr. Gonzalez. Anyone else you've spoken to, any other supervisors you've spoken to about this investigation you've not yet told us about?
That's what I recall.
Thank you. All right. Do you recall on how many occasions you did transmit policy information to Ms. Hochstein through any means?
No, I do not.
After Ms. Contreras told you not to communicate any further policy information to Ms. Hochstein, did you send any more information to her?
I don't believe so.
Other than policy information, was there anything else that Ms. Hochstein requested of you to your knowledge?
Yes, she requested documents.
What type of documents?
Documents from the case file.
And what was your response to that?
Initially, I said yes, and later I was told that that's protected information and I can't just send it
Who told
to
you
her.
that?
County counsel.
Do you recall his or her name?
Yes.
What was his or her name?
Leisha Schaefer.
Was that Leisha? How do you spell that?
Leiga.
S-C-A-F-F-E-R?
Schaffer, I believe.
Thank you. To your knowledge, is it Ms. Schaefer?
Mm-hmm.
Yes.
Yes.
Is Ms. Schaefer a county counsel appointed to the Department of Child and Family Services?
Objection, speculation?
To your knowledge.
What do you mean appointed?
designated, does she answer legal opinion? I'm sorry, does she express legal opinions on behalf of the department, to your knowledge?
Yes, she does.
Okay. Because I understand that the county council also is involved in writing petitions, correct?
Objection, speculation.
Is that
I
correct?
don't know what you mean, writing petitions.
The petition to have a child removed, does county council get involved in writing petitions to have kids removed?
Objection, speculation.
Are you saying they write the petition?
They're involved in writing the petition, aren't they?
Involved in what way?
Doesn't county council review it and get involved in the drafting of the petition?
Objection, speculation.
That's not my experience.
Okay.
Oh, what petition are we talking about? A warrant?
No, petition to remove a child. The juvenile court petition to remove a child. Let's just stick with the petition for right now. Do you recall if county council gets involved in reviewing petition to remove a child from its parents?
Objection, vague and ambiguous speculation.
Do you understand the question?
No, I'm sorry, I don't.
That's okay. We'll move on.
Okay.
Do you recall what I'm struggling with is this. I understand county council is involved in, so to speak, the day-to-day operations of the Department of Child and Family Services. And other attorneys can be involved to defend the county in ways that would exceed just what the Department of Child and Family Services is doing. So I'm unclear if Ms. Schaefer basically works within the Department of Child and Family Services as an on-staff attorney, or if she works outside, like for the administrative offices, and she was asked to consult in your case because it involved a civil rights investigation. Is that question clear?
Objection, vague and ambiguous speculation.
I don't know the difference between the two.
Got it. How about this? Before Ms. Schaefer advised you on this issue, had you consulted with her about clients and cases?
I'm going to
Yes.
object. I'm going to
Okay,
object
go ahead.
on the grounds of attorney-client privilege, and I'm going to ask you not to respond to questions about conversations that you've had with an attorney, with your attorney, Ms. Schaefer.
Okay.
So I'm going to ask you not to answer.
Okay.
And the one question I'm entitled to ask about that is, as you're laying this out, at this moment in time, you believe that Ms. Schaefer was your attorney, correct? You thought she was your attorney?
Well, yes, she.
Okay, I'm just saying it
I
wasn't
was consulting with her.
right. It wasn't a social thing. It wasn't by the water
No.
cooler.
Oh, no, no.
Okay. Okay. We've now covered these 4 individuals. Ms. Schaefer is the newest individual. We have 5 people. Is there anyone else that you've consulted with from the department regarding Ms. Duval's civil rights civil rights complaint that we have yet to speak of?
Not that I recall.
Okay. Now, at some point in time, did you learn that the civil rights investigation was concluded?
Yes.
Let me hand you what we will mark as exhibit number 12. I'm handing a letter of determination to your attorney dated July 29, 2010 from Ms. Hochstein, directed to you. Please take a look at that and let me know when you're done reviewing it. Ma'am, you've had a chance to review Exhibit 12, correct?
Yes.
And do you recognize it?
Yes.
That is a letter of determination from Ms. Sheele Hochstein, correct?
Yes.
if you read the first full paragraph, it says that the thorough investigation revealed a violation of client Rafaelina Duval's civil rights on the basis of national origin and disability. Do you see that?
Yes.
The next paragraph indicates that you shall not contact Ms. Duval or take any or engage in any conduct that could be seen as retaliatory. Is that correct?
Yes.
Okay. Let's go back to the first paragraph first and discuss your understanding. On the day you received this letter, what was your understanding regarding the substantiation of the violations based on national origin and disability, if any?
I understood that these two things were substantiated. I had no idea what it meant.
Okay. Had you had any warning prior to receiving this letter that the violation of national origin was going to be sustained?
No.
Prior to receiving this letter, had you had any warning that the violation based on Ms. Duval's disability was going to be sustained?
No.
Objection. Foundation assumes facts.
No, I did not.
So, to your knowledge, the address was given to us blacked out.
Mhm.
Was this mailed to your work address?
I don't remember.
Do you ever recall receiving a letter like this at home?
I don't remember if it came to work or home.
Okay. Do you recall seeing this letter?
Yes.
When you received it, you opened it and read it, correct?
Yes.
What was your reaction when you saw it?
Surprise.
Surprised because?
Because I did not know that Ms. Duval had any disability, and I had no idea what violation of her national origin was.
When you received this letter, did you make contact with anyone to discuss it?
I contacted Ms. Hochstein.
And what did she say to you?
I don't remember. She didn't really give me any information.
Did you telephone her?
I believe so, yes.
And you actually spoke to her on the phone?
That's what I recall.
And from the tone of your voice, I can tell even to this day you were astounded they sustained the violation, correct?
I believe, yes, I was astounded, yes.
Okay.
Yeah.
What information did Ms. Hochstein give you, if anything, at that moment in time?
I recall asking her, what disability does a client have? And she did not give me a reply.
Did she discuss anything else with you at that moment in time?
No, not that I remember.
So it sounds like your conversation was you asking questions of her and she really wasn't replying to you.
She just replied with what was here
On the telephone?
on the telephone.
Okay. Did you then talk to Ms. Vance about this letter?
I'm sure I did.
Do you recall when that conversation took place?
No,
Do you recall what Ms. Vance told you, if anything?
no.
Do you recall speaking to Ms. Contreras about this letter?
I don't recall speaking with her.
And during July 2010, were you still working out of the Lakewood location?
Yes, I was.
Do you recall speaking to the other individuals we've spoken of here today, meaning Mr. Gonzalez?
I believe I spoke to Mr. Gonzalez and told him that it was, substantiated.
What did he tell you, if anything?
I don't remember.
And how about, is it Mr., I'm sorry,
Barvez?
Barvez?
I don't recall talking to him. I may have, but I don't remember.
Now, when the letter arrived, who was your immediate supervisor?
I believe at this time I had a split caseload, and I was still reporting to Ms. Vance for FM&R cases, and I was reporting to Adrian Gonzalez for ER cases, ER referrals.
I see. Did anyone ever volunteer to you before that they had knowledge of a civil rights complaint being sustained?
I'm not understanding your question.
You spoke to these 4 individuals once you got the letter sustaining the complaint, correct?
Yes.
Did you ask any of these individuals, have you ever seen a letter like this before?
I don't recall showing them the letter.
Did you ever ask them if they were personally aware of a client's civil rights being sustained against a social worker before?
I don't recall.
You may have, you may not have, you don't recall.
I don't recall.
Let me go ahead and ask you to turn to what you've already got in your possession,
Mhm.
which will now mark as exhibit, quite all right, as exhibit 13. You'll need to turn the first page over.
Mhm.
Perfect. Hand it to the reporter. Thank you very much.
Thank you.
Now, we gave this to you, this document, Exhibit 13, prior to the break. You've had a chance to read it and review it, correct?
Yes.
This is the Civil Rights Report of Investigation prepared by Ms. Hochstein, correct?
Yes.
And as far as I can tell, the report is dated July 30th, 2010. It's on the front page there. That's your understanding as well, correct?
Yes.
Did you actually receive this report?
No.
You've never, strike that. Have you ever received this report?
From counsel prior to this.
Okay. I don't want to know what you and your lawyer in the room here talked about today. So let me approach it this way. Between July 2010
Mhm.
and up until the time you were being prepared for your deposition, were you ever provided a copy of Exhibit 13 in front of you, the Civil Rights Report of Investigation?
No.
So this document was not sent to you, to your knowledge, in July of 2010?
No.
And you're suggesting the first time you received this document was in regards to this litigation, correct?
Yes.
I don't want to speak to you about anything you and your attorney discussed
Mhm.
with this document. I want to speak to you about your reactions to reading and learning what this document has to say. Am I clear about that?
Yes.
Perfect, thank you.
Mhm.
Okay, so when you first read this document, what was your reaction to what it said?
When I first read it,
Yes, ma'am.
it was interesting to see, what her basis was.
Her basis being Ms. Duval or Ms. Hochstein?
Ms. Hochstein, how she viewed it.
Okay. Is interesting a euphemism for something else?
No.
You found it interesting?
I did find it interesting, yes.
Did you find it offensive?
Understand, I found it interesting because it was never explained to me. So,
So the whole thing was kind of curious to you.
since I never had an answer of even what it is, what's the disability, I had no answers before, so this was enlightening.
The letter you were sent as exhibit number 12 discusses the fact additional information will be forthcoming to you. And you're welcome to look at exhibit 12 again if you wish.
Oh, corrective measures.
Yeah.
Yeah.
So you were given a letter, which you did get,
Yes,
and the letter discussed corrective measures, right?
yes,
And that meant they were telling you you would have to undergo some form of corrective measures, correct?
Objection, speculation?
it says corrective measures.
Was that your understanding when you read that paragraph?
I had a hard time understanding the whole thing. So at this point, I was just waiting for whatever comes next.
It was foreign to you?
Yes.
Was it intimidating for you?
Objection, argumentative?
I don't think intimidating is the right word.
What word would you use?
Painful.
It was
Yeah.
painful that someone could attribute discriminatory conduct to you?
Not attribute it, necessarily, no, but that it was substantiated. Yeah, that was painful.
And I understand you're saying it was painful.
Right.
In your mind, was it painful because the county was concluding that you behaved in an inappropriate fashion?
No. The county?
Yeah, the county of Los Angeles.
No.
Do you know who sustained the violations against you initially?
Well, now that I'm looking at it, I do see the paper says County of Los Angeles.
Right.
Yeah.
So, do you understand now the county sustained violations against you, saying you act in a discriminatory fashion?
Objection, foundation, assumes facts not in evidence.
Let me repeat the question. As of July 2010, when you read the letter from Ms. Hochstein, you understood that Ms. Hochstein had sustained civil rights violations on behalf of Ms. Duval against you, correct?
Yes.
And that was painful.
Yes.
I'd like to understand, what was painful about that?
You're going to make me cry.
We can take a moment if you need to.
Let's take a break.
Okay, let's take a break.
This is the end of meeting number 2, the continuing deposition of Victoria Sheele, Volume 2. We're off the record at 3:23 p.m. We're back on the record at 3:38 p.m. This is the beginning of media number 3 in the continuing deposition of Victoria Sheele, Volume 2.
Ms. Sheele, we've had a chance to take a break, and you're ready to go forward?
Yes, I am.
Okay, perfect. And if you require another break, just let us know. We'll be happy to accommodate you, okay?
Thank you.
Our pleasure. All right. So you were going to answer the question. It's been read back to you before we
Yes.
started this session. Please, what's your answer?
What was painful about that? I came of age as a young adult during the time of the civil rights movement, the women's movement, and I actively embrace and support that. And I've seen great progress. And we're not all well yet, but it's a personal value of mine to treat every person with dignity and respect. So it was very painful. That's one aspect of it. Second aspect of it was that I didn't know why. I didn't know what I had done. I didn't understand it. I had no explanation. And then, actually, I've read this twice. I read it again the second time today, and I noticed that Ms. Duval had provided Ms. Hochstein with documentation of her, apparently of her doctor's information on her her tremors, and perhaps something on allergies. And that information was never given to me, and it was never, I was never even asked, did you see this documentation where you asked for accommodations? So, I had no opportunity to accommodate anything.
And you're saying that you had no chance to respond to Ms. Hochstein's investigation because you were unaware of a lot of what the concerns were.
Objection, misstates testimony.
Is that question clear to your mind?
I don't think that's what I just said, but maybe I'm confused.
I want to make sure I got it right, which is why I'm asking you the follow-up question.
Okay, sorry, what is the question?
It's okay. And again, if I'm ever unclear, please let me know.
Okay.
As I understand it, you're saying that Ms. Duval never notified you that she was disabled.
That is correct.
And had she notified you that she was disabled, you would have noted that in your service log.
I would have not only noted it, but asked if she needed an accommodation and discussed that with my supervisor. There are things that can be done, but you can't do anything if you don't know. That's one piece. Secondarily, during this investigation, I believe what I said is that Ms. Hochstein did not ask me had I received any notice. I mean, I don't know if she just assumed that I'd received some kind of notification, but I had no opportunity to address that here.
In the civil rights complaint,
That's right.
in the civil rights investigation.
Yes.
And that's what my question was about a moment ago. So we're clear now. Your position is that Ms. Hochstein never gave you a complete understanding of Ms. Duval's concerns regarding her disability.
Yes.
And more specifically, Ms. Hochstein never explained to you Ms. Duval's disability discrimination concerns.
Yes.
And Ms. Hochstein never gave you a fair chance to respond to Ms. Duval's disability discrimination claims.
I had no knowledge and no opportunity.
And just so we're clear, when you had the meeting with Ms. Hochstein, you did not take your union rep, correct?
No, I did not.
And to your knowledge, you only had a single meeting with Ms. Hochstein regarding this investigation, correct?
That's all I had with her.
Now, you mentioned that you've reviewed exhibit number 13, which is in front of you, the report we're going to go through in a minute.
Okay.
This is dated again July 30th, 2010. Are you aware of any subsequent reports from Ms. Hochstein regarding your conduct?
No.
So if Ms. Hochstein generated a second report after this report regarding your conduct, you're unaware of it?
I have never seen anything further. The only thing I ever saw was this letter. I never even saw this.
I understand. And let's do this because we're pointing to
Okay.
this and we're using words that are abstract.
Okay.
What you're saying is that prior to the litigation, you never saw Exhibit 13 in front of you, which is the July 30th, 2010 Civil Rights Report of Investigation, correct?
That is correct.
And you did, however, see Exhibit 12, which is the July 29th, 2010 letter from Ms. Hochstein to you.
Correct.
But you never had any information regarding the report, which is before you as Exhibit 13.
That is correct.
And if Ms. Hochstein wrote any additional, let me rephrase that, if Ms. Hochstein wrote an additional report or additional reports, you're completely unaware of that.
I never received anything else.
Let me just jump ahead for a moment to clarify something. Let me draw your attention to page 10 of 12 on Exhibit 13 in front of you. Please take your time and turn to page 10 of 12. Let me know when you're there.
Yes.
Do you see the conclusion section?
Yes.
Sorry, that's the wrong section. Let me just ask the question. To your knowledge, was it ever recommended that you receive any type of training as a result of Ms. Hochstein's investigation?
I was never contacted and asked to participate in any training, no.
So, you never underwent any type of record reporting training because of this incident?
No.
You never underwent any cultural sensitivity training because of this incident?
No.
Has anyone ever spoken to you about the county policy for monitored visits and having clients understand the policy which requires them to communicate with their kids in English or request an interpreter monitor the visits?
I'm sorry, state that again?
Let me rephrase it. I'm sorry, that's a bit much in one question. It's true, ma'am, that when monitored visits begin with the Department of Child and Family Services, the client has to agree that the conversation with the child will take place in English, correct?
In their language, the language they designate.
Yeah, we're going to, okay, thank you. So, so they have the right to designate a foreign language, and then the department provides an interpreter in that language. Is that correct?
They designate their language, and we provide not just an interpreter, we provide a CSW in their language, we provide a visitation monitor in their language, as far as possible, yes.
Okay. So, and that's at the county's expense?
Yes.
Do you know at this time, I'm sorry, you now work in the ER unit, correct?
Yes.
When you last worked in the family reunification unit, do you know if there were Spanish interpreters available?
We had Spanish-speaking social workers in FM&R, yes.
So would the Spanish-speaking social worker appear and monitor the visit, or would they actually translate between anyone else there that may speak English and the person who speaks Spanish?
I'm sorry, please
Let me
say
make
that
it more
again.
concrete for you. Sorry. Would you agree, ma'am, that if the family attends a monitored visit, they have the right to speak their native language or designated language with the child?
Objection, compound.
Do you understand the question?
It's a little bit complicated.
Sure.
CSWs are assigned to cases. I'm not assigned to Spanish-speaking cases because I do not speak Spanish. So the language designation from the beginning is what determines your language for the case, which determines whether you are assigned a Spanish-speaking worker or an English-speaking worker.
And is there ever the case where family has the right to request an interpreter be present during a monitored visit to translate for them?
Objection, speculation.
It's your policies.
I think we need to differentiate between what the court is ordering. So if the court is ordering that Spanish-speaking family members attend visitation, then I don't know what that would do. If that would change the designation on the case, you know, it's a separate
Okay.
kind of issue.
Thank you. We'll keep moving forward.
Okay.
All right, so let's turn back to the first page before you.
Mm-hmm.
And let's turn to page 2 now. Let's draw our attention to statement of allegations. Do you see that?
Yes.
And number 5, disability. Do you see that?
Yes.
Oh, I'm sorry. You know what? Let's back up to number 4 for a moment.
Mm-hmm.
Take a second, please, and just read bullet point number 4 to yourself. Let me know when you're done.
Sure. Yes, I'm finished.
Okay, do you have any recollection of a conversation occurring between you and Ms. Duval where you advised her she could not sing to her child in Spanish?
Yes.
And what was the reason for that?
Because I don't speak Spanish, so therefore I can't understand what she's singing to her child in Spanish. The child is bilingual, I am not.
During that circumstance, is there an obligation by the department, to your knowledge, to provide an interpreter to monitor the visits?
Objection, speculation.
I don't know about the word obligation.
Okay.
I'm not clear what the obligation would be.
Let's just change it. Does the department provide interpreters under those circumstances?
Objection, incomplete hypothetical, speculation.
What we attempted to do was find a Spanish-speaking monitor. At the time that this issue arose, it was summer, and our Spanish-speaking monitor was on vacation. So at that moment in time, right then, we were unable to accommodate that situation.
And why was it that Ms. Duval was not assigned a Spanish social worker, to your knowledge?
It is, to my knowledge, because in the beginning of the case, she signed the language designation as English. We were not asked to provide an interpreter in court. It was an English-speaking case. Therefore, English-speaking cases are assigned to English-speaking workers.
And so I understand, does the family member or client pay for the monitor, or does the department pay for the monitor?
The department.
And is there any reason why Ms. Duval was not provided a Spanish-speaking social worker throughout the pendency of her case when you learned she wanted to sing to her child in Spanish?
Objection, speculation.
I'm sorry, can you repeat that?
Let's read the question back.
Question, is there any reason why Ms. Duval was not provided a Spanish-speaking social worker throughout the pendency of her case when you learned she wanted to sing to her child in Spanish?
Do you understand the question now?
Yes.
Okay, please answer it.
To my knowledge, at that point in time, she did not request a Spanish-speaking social worker. I do believe she requested a Spanish-speaking monitor, which we did not have on hand at that moment.
To your knowledge then, at that moment in time, you only had one Spanish-speaking monitor?
No, there's more than one in the building. They're assigned to units. So it's my understanding that the one that might have been available to us was on vacation.
I see. Okay. Now let's go back to number 5, if we could,
Mhm.
on page 2.
Mm-hmm.
Let me ask you to read that section. Please advise me when you're done.
Okay. Yes.
To your knowledge, did Ms. Duval ever disclose to you that she was allergic to things such as dust?
I don't recall her mentioning dust.
Do you recall other allergens that she reported being allergic to?
I recall her mentioning food allergies.
Do you recall her reporting that the room was filthy and she had to clean it because she's allergic to some allergens in the room?
No.
To your knowledge, did any other client ever reported the room as being dirty or filthy to you?
I don't recall.
It may have happened, it may not have happened, you simply don't recall.
I don't recall.
And it's true that you were documenting her tremors in your service logs, correct?
Yes.
And I understand your testimony today that your belief is she never reported to you that she suffered a neurological condition which caused those tremors. Is that correct?
That's correct.
And to your knowledge, had she reported those tremors to you, what would have been your response?
Well, first of all, that would be an explanation for the tremors. I would have asked to see medical documentation of that. And at that point, it would not have been recorded in this manner.
How would it have been recorded?
I don't know that it would have been recorded at all.
And I'm going to do objections, speculation, incomplete hypothetical.
You also understand there was a concern about Munchausen's by proxy. Is that your understanding?
I understand that it was mentioned, yes.
Did you have any conversation with Ms. Hochstein regarding this Munchausen's issue?
That was a question she asked me, yes.
And what was your understanding of what she asked you about Munchausen's?
You know, I'm a little flustered from being upset. It would help if I could just look at the question. I know she asked me about it. I know I had a response to it, but I'm not feeling particularly sharp at this moment.
Okay. The one thing we don't want to do
Okay.
is get bad testimony from you.
Okay.
So I appreciate the fact you're a bit flustered.
Okay.
Nobody wants you to feel uncomfortable when you're testifying today. Do you want to take a moment and speak to your counsel to make sure you're giving your best testimony? And let me explain what's going on. You've already been advised, I believe, that at the end of your deposition, you'll have a chance to review your testimony, correct?
Yes.
And you've been advised that you'll have the right to make any changes that you see fit to the transcript, correct?
I don't remember that, but okay.
Okay. And what we're concerned about is if you start testifying one way and then you read pages of your deposition and realize you have more information or you want to change your answers and you start making a lot of changes, then we need to have you come back and talk to you again to get it straight. We want to avoid that. Nobody wants you to testify if you can't give your best testimony. So let's just take a minute, have you talk to your attorney for a moment and make sure you can do that, and then we'll go forward if you're prepared to go forward after that, okay?
Sure.
We are off the record at 3:57 p.m. We are back on the record at 4:06 p.m.
Okay, we've had a chance to take a break, and I appreciate you telling us that you're a bit tired. We've talked about it with your counsel and you off the record, and we've offered you the chance to end the deposition for today and come back again later. The principal goal is to make sure that when you testify today, you give your best testimony. There's no concern going forward that your testimony will be anything other than your best recollection. You've indicated to us you feel well, and you're prepared to keep testifying right now, correct?
That is correct.
And if you do feel unwell, or you feel as if you're not giving us your best testimony, you are going to tell me so we can stop for the day, correct?
Correct.
Fabulous. Okay. Thank you for your cooperation. All right, so back to the document. We were talking about the Munchausen's by proxy. Do you recall that?
Yes.
And the issue was, had you become aware that there was a suggestion that Ms. Duval suffered Munchausen's by proxy?
I'm sorry, can you repeat that question? I just didn't catch it. I
I
apologize.
didn't get it either.
It's foundational. I'll just rephrase it.
Okay.
At some point in time, did you learn that there was a concern Ms. Duval suffered Munchausen's by proxy syndrome?
I don't believe it was a concern that she suffered it. I think it was a concern that it should be ruled out.
And in your mind, what does that rule out condition mean versus she suffered Munchausen's?
That it should be looked into and ruled in or ruled out.
And how would one do that?
Objection, speculation, calls for expert opinion.
In your experience, how would one do that?
Same objection.
To my knowledge, it would be, one way would be a 7:30 evaluation.
A jury's a lay organization, so a 7:30 evaluation is a court-ordered process where the court orders the client to undergo a mental health exam, right?
Yes.
And the purpose of the mental health exam is, as you're discussing, is to confirm or to discount the presence of Munchausen's by proxy syndrome by the client, correct?
Yes.
And the purpose of that would be to make sure if the client suffers Munchausen's by proxy, the court is apprised of that in making child custody decisions, right?
Objection, calls for legal conclusion, speculation.
Do you understand the question?
Say that last part again. The purpose?
Sure. Let's just have the question read back.
Okay.
Question, and the purpose of that would be to make sure if the client suffers from Munchausen's by proxy, the court is apprised of that in making child custody decisions, right?
That would be one reason to do it, certainly.
What are the other reasons in your mind?
I'm by
Objection,
far...
speculation, calls for narrative, calls for expert opinion.
I'm certainly not an expert, nor am I qualified to, in the area of Munchausen.
Right. You mean that you're not qualified to render an opinion whether someone has or doesn't have Munchausen's, right?
Correct, and I'm also not an expert on the problem itself. So yes, that would be one reason.
Thank you. But what I'm asking is, as a social worker conducting an investigation, which will ultimately advise the court on where a child should be placed, it's important for you to understand whether or not one of the parents has Munchausen syndrome, right?
I'm not.
Objection calls for expert opinion, speculation.
I'm not conducting an investigation.
The department is, right?
Department
The Child and Family Services?
I'm not an investigator on this case.
I understand. But
Okay.
the department is conducting an investigation, correct? Let me phrase that and withdraw it and go back in time. That could be some of the confusion. This document was written in 2010, correct?
Yes.
And the Duval case was opened in 2009, correct?
Yes.
Do you recall when the case was closed?
2010, August, I believe.
Okay. So, if this report by Ms. Hochstein was authored in July 2010, and your belief is that Ms. Duval's case was closed in August 2010, her DCFS case was open when the Civil Rights Investigation Report was issued, correct?
Yes.
Okay. So going back to that time frame, 2009-2010,
Yes.
it's true the department was running an investigation regarding the placement of Ms. Duval's minor son, correct?
I'm unclear that there's an ongoing investigation.
We're talking about 2009-2010.
Perhaps it's my current work in ER that's leading to confusion.
No, it's probably we're just use different language. So let me try and make sure I use language that we both understand. Thank you for telling me when you don't understand the question. It's true that the department does not just randomly remove children from their parents, correct?
Yes, that's correct.
The department has a process it goes through to investigate the allegations, confirm or deny them, and then make appropriate recommendations for the court to act upon, right?
Yes.
And I understand what you're really trying to say, I think, is that when you were facilitating the monitored visits, you were not investigating the placement of the child, correct?
Correct.
What you were doing was simply supervising the monitored visits and reporting what occurred during the monitored visits to others so they would continue to make recommendations to the court, correct?
I was putting the contacts in the contact log regarding the visitation.
I thought earlier you said that one of the most important determining factors in having a child reunified with their family or not is the fact the family came to visit the child for monitored visits.
I don't believe I said important.
Is it important? Is that an important factor?
It's a predictor.
And what do you mean by that?
Families that visit tend to take the actions that the court is requiring of them to facilitate reunification. If a family doesn't visit, they're probably not going to reunify.
And yet, in this case, Ms. Duval did visit her son, correct?
Yes.
On a regular basis.
Yes.
And she rarely, if ever, missed visits with her son, correct?
Correct.
And the department did not recommend reunification for Ms. Duval, correct?
I don't believe so, no.
And in your mind, is there any explanation you can help me understand why, when she was appearing for her monitored visits, given what you just testified about monitored visits, why she would be denied reunification?
Objection, speculation.
It's my understanding that the case turned on what happened to the child while he was in mother's care.
Before there were monitored visits.
Yes.
As part of your involvement in Ms. Duval's case, did you have the authority to order Ms. Duval for a 7:30 evaluation?
No.
Did you have the authority to recommend to the court they order a 7:30 evaluation for Ms. Duval?
I was not writing to the court.
Could you have made recommendations to other social workers involved in the case to have Ms. Duval undergo a psychiatric evaluation to confirm or rule out Munchausen's?
Yes.
Did you?
I don't recall whether I did, but I do concur with it, that it would be a good idea.
Any reason why you didn't?
I believe it was already mentioned in the report before I ever did anything here.
You're speaking of the upfront assessment.
No.
Which report are you? I'm sorry. Which?
I'm speaking of the PRC.
What the PRC stands for?
I'm sorry, we use a lot of acronyms.
Yeah, I understand.
It's the first report after the detention report. Pretrial resolution conference.
Let me have you turn to page 3 of Exhibit 13, Section 7. Please take a quick moment, review that. It's just the next page.
Page 3, section what?
7 on top. Marital status.
Yes.
Please take a second, review that. Let me know when you're done.
Yes.
Do you have any understanding where Ms. Hochstein drew the quotation from the most appropriate adult in the child's immediate circle, end quote, was the stepmother? And the stepmother sentence was just before the quote.
I believe it's from the PRC report.
Okay. Let me turn next to page 4. There is your name. Do you see it?
Yes.
SOI. Do you know what SOI means?
Subject of investigation.
Was that explained to you by anyone?
I don't recall.
If you read that strike that. If you read that paragraph to yourself for a moment, I have some questions about it.
Okay. Okay.
It says there, at about the third line, her duties, meaning your duties, include monitoring CP Duval's visitation with her son, making referrals to appropriate service providers, and assessing both parents' ability to care for their son. Do you see that?
Yes.
Do you agree with that statement insofar as Ms. Hochstein's description of your job at that time?
I think it's a partial description of my job.
Well, okay. I realize omission can be an issue, but for the moment, is what that which is written there, that is accurate, correct?
I believe so.
Okay, what is omitted from that statement that would make it more complete?
There's a big list of duties.
Okay, do you want to share them with us?
It depends on the case.
Well, let me draw your attention to the making referrals to appropriate service providers. Do you see that?
Yes.
What is your understanding, if any, as to what she was referring to?
Again, depending on the case, we're going to refer the clients to whatever kind of service providers would meet the needs of that case.
Would that include a mental health provider for mother?
It would include a mental health provider for mother, yes.
Now, we did discuss your Munchausen experience previously. To your knowledge, if mother were confirmed to have Munchausen's, would that preclude her ability to get reunification services with your child if, for example, she underwent mental health counseling for the issue?
Objection. Foundation, incomplete hypothetical. speculation, calls for a expert opinion and a legal conclusion.
And let me clarify one thing that I think your counsel is pointing out. We both understand that you don't decide the issue. You make recommendations to the court to decide the issue, correct?
Yes.
Okay. So I'll ask the same question with the caveat that we're talking about a recommendation to the court. So if a parent were confirmed to have Munchausen's and they were undergoing treatment for the Munchausen's, in your experience, would that preclude the parent from receiving reunification services?
Objection, incomplete hypothetical, speculation.
I have absolutely no experience with the Munchausen case.
So you couldn't answer that question?
I have no experience.
Okay. Let me draw your attention down to the first full paragraph below race. I'm going to read a line to you and ask you to confirm whether, based on your belief, it's true or false. The father was the most likely candidate for placement because his whereabouts were known, and he did not appear to be responsible for the child's FTT because of his marginal parental involvement.
Objection calls. Well, sorry.
I'm
What's
just
the
asking
question?
you to get to that first. So I've read it to you. You can find it in the document. I'm going to ask you a question about it. I can show it to you as well if you need me to. Did you see it?
Yes.
My question is, do you concur with Ms. Hochstein that Mr. Duval had marginal parental involvement prior to the DCFS investigation?
Objection, foundation, assumes facts not in evidence, speculation.
You can ask the question based on your understanding.
My understanding is that he had very little involvement at this point in time.
Okay. Let me draw your attention to about 3 paragraphs down. It says SOI Sheele indicated she could not comment on placement because the child was placed before she got the case. She noted per DCFS policy, the first place to look for placement after a child is detained is with the child's family. Do you see that?
Yes.
Is that an accurate reporting of your conversation with Ms. Hochstein?
I believe that's what she wrote on the paper, yes.
But is it what you believe you told her at the time of the interview?
I can't remember.
That's fine. And if you don't know, you don't know. But
I can't
appear-
remember.
The,
On the face,
the statement appears accurate. It's on its face.
yes.
Okay. Do you ever go on Facebook and review Facebook for the clients that you're actively working with?
No.
You're smiling. That's a strange question.
I think it's generational.
I understand that. Let's go down to the bottom of page 5. Again, it has your name reported in the first part of the paragraph. SOI Sheele confirms she asked CP Duval to sing to her son in English instead of Spanish because the visits are to be conducted in English only, and SOI Sheele does not speak Spanish. Do you see that?
Yes.
Is that an accurate statement of what occurred in Ms. Duval's case?
Yes.
Do you recall Ms. Duval ever seeking permission to sing to her son in Spanish?
I do not.
Do you ever recall Ms. Duval making contact with the department, seeking to modify her initial designation regarding which language she wished to communicate with the department in?
Yes.
And what happened there?
The case was to be transferred to a Spanish-speaking worker.
To your knowledge, was it ever transferred?
I believe it was at the very, very, very end.
And by end, I'm not sure what that means. Can you help?
It was, we were already in trial, I believe. And that's my best recollection of it.
And to your knowledge, is it within the client's ability to request a change during the process of the investigation?
Yes.
And how long does it customarily take for a case to be reassigned from, say, an English social worker to Spanish social worker?
I don't know.
There is a sentence, I'll read it to you in the part of the same paragraph. It says, we don't have a Spanish-speaking monitor available to monitor, parenthesis, CP Duval's visits, end quote. We've already discussed that that was your belief, that the monitor assigned to this unit was on vacation at the time.
I believe so.
You also indicated that you thought Ms. Duval's son spoke, quote, quite a bit, end quote, of both English and Spanish. Did you actually tell Ms. Hochstein that?
I don't say that he spoke. The child did not speak very much at this point in time, but he understands.
I'm sorry if I misspoke.
Mhm.
So, just to be clear, your belief is that you did tell Ms. Hochstein, it was your belief that Ms. Duval's son understood quite a bit of both Spanish and English during your time with the family.
Yes.
What do you base that observation upon?
The fact that the child has been in a bilingual home for most of his life, and that Ms. Duval had her mother as a babysitter when she was at work, is my understanding. Also, the child was cared for while father and stepmother worked by Spanish-speaking step-grandparents.
I see, thank you. Anything else?
No.
Let me draw your attention to page 6. You've already had a chance to read this document, correct?
Yes.
Let me draw your attention to the middle portion of the page, where it starts, also, according to DCFS policy 0400-504.45, supervised visits, SOI Sheele meets the definition of a professional monitor. Do you see that?
Yes.
Earlier we were talking about different types of monitors and how they are defined. Do you recall that?
Yes.
Does this document help refresh your recollection that you were a professional monitor?
Yes.
And would that be a classification you accept?
As part of my job.
Yes. Professional monitor.
Yes.
Okay. And as part of your training, it suggests that you should have been trained in cultural sensitivity. Do you understand that?
Yes.
Is that accurate, that you were trained in cultural sensitivity as part of your training?
Yes, I was.
At any time do you recall discussing vaccinations with Ms. Duval regarding her son?
Yes.
What was discussed in that regard?
It is in my contact, and I recall that she approached me. I believe she requested information on his vaccinations. As I recall, I referred her to the medical records.
Did you ever discuss with Ms. Duval the fact that the child's father had as much right to vaccinate the child as Ms. Duval had not to vaccinate the child?
I don't believe I discussed that with her. I don't recall that.
Would you normally discuss such an issue with a parent?
Only if they were asking me.
And obviously it's an adversarial process if the parents are divorced or there's two sets of parents. So do you have any understanding as to which parent has the right to vaccinate a child or not?
Objection calls for legal conclusion, speculation.
Do I have an understanding of which parent has a right to vaccinate?
Yes, ma'am.
Both parents have equal rights.
Okay. With regard to family unification services, do you recall providing Ms. Duval a case plan recommendation services, which included psychiatric, psychological evaluation, counseling, and parent education?
Yes.
And is it true that Ms. Duval refused to sign the plan?
Yes.
What does this plan consist of?
It consists of information on the history of the case, what led to the detention, and recommendations for reunification services for the parents. It also usually includes something for the child.
Does it include a statement or an admission by the parent that they are a bad parent?
Objection, big and ambiguous.
An admission that they're a bad parent?
Yes, ma'am.
I don't know.
Have you ever seen a document authored by the department given to a parent where the parent's supposed to admit that they are in some way deficient in providing services to their minor?
I'm not aware of it. It doesn't. I just don't remember seeing something like that.
Okay. The psychiatric psychological evaluation component of the plan we are discussing,
Mhm.
what does that involve?
I would have to look at the plan. I don't remember it.
Does it normally involve an evaluation for Munchausen's by proxy when there's a concern with Munchausen's by proxy?
Objection, incomplete hypothetical speculation.
I would think I don't have a lot of experience with 730 evaluations, but I would expect that it would cover everything.
Do you know a social worker with the department named Elba Pinedo?
I don't recognize the name.
Do you know who wrote the petition to remove Ms. Duval's son from Ms. Duval's care?
I do not.
The document in front of you at page 6 reports that if the petition, which means the department's petition, were sustained, Ms. Duval would not be eligible for reunification, and the Welfare Institutions Code section is referenced there, for severe neglect. Do you recall having that conversation with Ms. Hochstein?
I don't recall the conversation, no.
The statement, however, is correct that if the petition were sustained, Ms. Duval would not be eligible for reunification. Is that correct?
Objection, calls for legal conclusion.
I believe the court has discretion on this.
Do you believe that you told Ms. Hochstein that the court had discretion on this point when you were speaking to her?
I don't recall.
Okay, you understand, I'm just trying to understand.
Right.
Let me rephrase that. I wasn't in the room when this conversation occurred, if it ever occurred. So I
Right.
want to understand from you what you recall, if anything, about this conversation. Having viewed the document, does it refresh your recollection and allow you to testify about anything in that conversation?
I don't recall this portion. It's been a long time.
Understand.
Okay.
Let's turn the page and go on to page 7. Let me draw your attention down to where it says disability. Do you see that?
Yes.
I'm going to ask you to read the first full paragraph to yourself. You've already had a chance to read it, so we'll just keep moving through this document.
Just the first paragraph?
Yes, ma'am?
Okay.
For right now?
All right.
You've had a chance to read it?
Yes.
Let me draw your attention to the second line of the paragraph. SOI Sheele disregarded CP Duval's claim her tremors were related to a medical condition. You see that?
Yes.
Based on your testimony today, you're saying that Ms. Duval never reported to you that she had a medical condition which caused tremors?
That's correct.
And Ms. Hochstein never discussed this issue to make you aware of the fact that Ms. Duval was alleging that she had a medical condition that caused her to suffer tremors during the civil rights investigation, correct?
That is correct.
Is it true that I'm sorry. Let me draw your attention to the last sentence of that paragraph. SOI Sheele's observations about the tremors, which is misspelled, were noted in the court reports as evidence of CP Duval's anxiety regarding caring for her son. Do you see that?
I'm sorry, I'm not.
Okay,
What
just
paragraph are we on?
The same paragraph.
Oh, okay, sorry.
That's
I
all
was
right.
down below.
Yes, ma'am. The last full sentence. SOI Sheele's observations about the tremors were noted in the court reports as evidence of CP Duval's anxiety regarding caring for her son. Do you see that?
Yes, I do.
Is it true that you documented that you thought Ms. Duval's tremors were a manifestation of anxiety regarding caring for her son?
Objection, speculation. Foundation assumes facts.
Ms. Duval told me about her tremors, and she said they are worse under stress. When I observed her tremors to be worse was when she was doing something for her son.
I understand you testified when she was touching her son earlier.
Yes.
And I'm trying to simply corroborate the statement. Did you tell Ms. Hochstein this information during the investigation?
About what Ms. Duval told me, yes, I did.
Okay. So when Ms. Duval discussed her tremors with you, your position is during that discussion she never disclosed it was a family condition.
She told me that her brother and her father also had this condition.
Did she ever explain to you it was a medical condition?
No.
Did you form any belief regarding what she was talking to you about when she was saying her brother and her father had it?
No.
Well, she just told you that her brother has it and her father has it. Did you understand why she told that to you?
No.
Did it strike you as being odd?
It didn't, because it's not something I'm familiar with.
Did you ask her to clarify what she was talking about?
She clarified it and told me it's worse under stress.
The tremors,
Yes.
but not the origin of the tremors.
I don't know what the origin of the tremors is,
Exactly. At
other
no
than
time,
stress.
I understand. At no time did she ever disclose to you the origin of the tremors was an underlying neurologic condition.
Objection, foundation, assumes facts, not in evidence.
No, she did not.
You were aware of the fact that Ms. Duval alleged that she had allergies, right?
I'm aware of her mentioning that she had allergies, yes.
In your mind, did her allergy condition ever play a role in her son's weight when you first encountered him?
Objection, foundation, assumes facts, calls for speculation.
Do you understand the question?
It's a bit broad.
I understand. That's why it's
So-
start off broad. Let me rephrase it for you
No,
if I could.
please rephrase it. Thank you.
Ms. Duval's son was of a low weight when you first encountered him, correct?
Yes,
That was part of the failure to thrive diagnosis, correct?
I believe so, yes.
To your knowledge, was Ms. Duval's allergies ever considered a reason why her son had a low body weight?
Objection, vague and ambiguous, calls for speculation, calls for expert medical opinion.
To your knowledge.
I'm having trouble with it because the question is so broad.
Sure.
I recall that there was some evidence from somewhere that there was concern that due to her allergies, she was not feeding her child certain foods and was relying on breastfeeding so as to not, due to fears that her child would develop allergies. I do recall that being part of the...
Do you recall as part of that, there ever was a concern that mom was not offering food to child because of her own allergies?
To the best of my recollection, there was some documentation that mother was not feeding certain foods because she was allergic to the foods and had concerns for Ryan also developing allergies, and also was relying on breastfeeding to help prevent allergies from developing in her son.
Okay. Let me draw your attention to the bottom of the page, page 7, where it says SOI Sheele confirms she observed CP Duval's hand shake. Do you see that?
Yes.
And sitting here today, you recall that Ms. Duval's hands would shake.
Yes.
Can you describe for us how bad or basically how severe or mild the shaking was? What did it look like?
It varied from very severe tremors to no tremors at all.
Have you ever seen a Parkinsonian patient?
Yes, I have.
And they have very violent tremors, right? They can.
The one I saw did not have, but I understand they can.
Okay. Did you ever discuss whether she had a Parkinsonian type condition?
I did not.
So you never inquired if her tremors were caused by Parkinson's type disease?
I took her at her word that she had tremors, that they didn't bother her, or that they were worth under stress.
Okay. And you would agree that the whole process of being evaluated as a parent and placement and the entire DCFS process is stressful for the clients, right?
I would expect that it is, yes.
Because you're talking about potentially permanently removing a child from a parent,
Objection, speculation.
right?
There's always that potential, yes.
Which is scary for the parents, right?
Objection, speculation.
I would imagine.
Okay. The bottom of the page on page 7, we've talked about it. Let me draw your attention to it. Let's confirm it pretty quickly. It's Ms. Hochstein's reporting a conversation where apparently you reported Ms. Duval's hands would shake, and also that you recalled Ms. Duval informing you that she, her brother, and her father all have the same tremors, and it's worse under stress, right?
Right.
Okay. And then the next line on the next page, page 8, is that you document Ms. Duval's hands shake, quote, all the time, end quote. Correct?
Yes.
As you sit here today, do you recall her hands actually shaking all the time?
That isn't what this says. Her hands don't shake all the time.
I'm sorry.
Or that, I don't believe that's the meaning of that line.
Okay, let me read it so we avoid any confusion.
Okay.
SOI Sheele reported, and that means to Ms. Hochstein, she documented, quote, all of the time, end quote, that CP Duval's hands shake as part of her assessment of the CP. I think you're correct. What you're saying is whenever Ms. Duval's hands did shake during your presence, you reported each occasion or all of that time.
That is correct.
Okay, thank you. We talked about the shaking of the hands with the presence of her son. And then you've already explained it's quoted here as might be, end quote, stressful when she takes care of her son. You've already discussed that, correct?
Yes.
Now, Ms. Hochstein documents that the service log shows at least 9 times that you reported Ms. Duval having tremors. Do you see that?
Yes.
Let me just ask your recollection. Is it your recollection that on at least 9 occasions you documented Ms. Duval having tremors?
I don't recall the number. I would need to go through and count.
But you have no reason to disagree with what Ms. Hochstein's written here, correct?
Unless I counted it, then I might disagree.
Okay, but you have, as you stood right now, you know of no reason to disagree with her.
No.
Let me draw your attention about 2/3 of the way down page 8. It talks about SOI Sheele stated, quote, in the DSM-4-TR, it's called, quote, fastidious disorder by proxy, end quote, and double quote there. Do you see that?
Mm-hmm.
Yes?
Yes, you see it.
The DSM is the Diagnostic Statistical Manual number 6, right?
Number 4.
4, okay, sorry. I'm writing my Roman numerals here. So it's the DSM number 4, and what does TR mean?
Don't know.
Is it just the current version you're aware of?
The number 4 indicates the current version. I don't remember what TR stands for.
Was this one of the pieces, well, first let me ask this. Do you recall supplying this information to Ms. Hochstein during her investigation?
Yes.
Was this the type of information that Ms. Contreras said you should no longer provide to Ms. Hochstein?
That's not my understanding, no.
It was just the policy information and speaking to her over the telephone?
That's my understanding. Or, in general, just let it be.
Right. Don't provide any further information unless you see me first, kind of thing.
No. No.
What's wrong with that statement?
I was never asked not to provide any further information without talking to anyone, ever.
So she said just don't proactively provide information to Ms. Hochstein? Just
No.
let it be?
No. That Ms. Hochstein had received more than enough information from me. That apparently I overprovided. And she didn't need policies. They were available at her fingertips. So it was not at all a conversation to saying don't provide them information. Not at all. It was just like, you've provided her more than she wants. Just
Enough
stop.
already.
Enough already. Exactly. Yeah.
And then Ms. Hochstein's reporting that you told her that Ms. Duval had not been diagnosed with fastidious disorder by proxy, correct?
That's correct.
And that's your understanding?
That is my understanding.
And the only place this disease was mentioned was in the jurisdictional disposition report dated 1/4/2010, correct?
Objection, speculation.
I don't know that that's the only place.
I understand.
That is a place.
There's a statement there by Ms. Hochstein, and I'm trying to understand if she's trying to attribute it to you or not. Do you know if you made such a statement to her during your sessions?
What's it?
What statement?
It has only been mentioned in the jurisdictional disposition report dated 1/4/2010.
Oh, right here. What I believe this, well, I'm just guessing.
Don't guess.
It's hindsight. I mean,
All right. Let me draw your attention to the next page, page 9. Let me draw your attention to the third paragraph where it says SOI Sheele has not responded to this request for information. Do you see that?
yes,
This is about allergies. Do you see that?
yes,
Do you recall failing to respond to any requested information by Ms. Hochstein for this topic?
I responded on all of her topics. Apparently, I wasn't timely.
You were late.
Well, apparently, I didn't respond in time to be included in this.
Okay. So you believe if she had some later report, she might have had time to include whatever you gave her on this allergy topic?
I'm assuming that she would include whatever I gave her.
Okay. Let me draw your attention to the next time your name is referenced under age, where it says SOI Sheele has not responded to this request for information. Do you see that?
Yes,
Same question. Do you recall giving her information regarding age discrimination?
I responded to all of her requests
Just perhaps not timely?
in time for this.
Okay, let me draw your attention to marital status. About halfway through the first paragraph, it says, according to SOI Nelson, the father never posed a threat to the child's safety. Therefore, placement with the father would have been appropriate whether or not he was married. Do you see that?
Yes,
My question is, you were working in the family education unit, right?
yes,
Was Ms. Nelson also working in the same unit at that time?
no.
Is there any reason why Ms. Nelson would be commenting on a reunification issue, which would be part of your department's analysis?
Objection, speculation.
You can testify as to your knowledge.
I'm sorry, repeat the question.
Broadly, do you have any understanding of why Ms. Nelson would offer this information to Ms. Hochstein when you were working in family reunification and she wasn't?
Well, I believe she's responding to the query regarding marital status. Isn't that what she's doing here?
Yes.
Okay.
Okay. Let's turn to page 10. Let me draw your attention to review of supplemental information on page 10. Do you see that?
Yes.
On the last full sentence, on the second paragraph, it says, a review of SOI Sheele's CWS-CMS documentation dated 7/22/2010 indicates on July 6, 2010, CP Duval's child weighed 17.95 pounds. Do you see that?
Yes, I do.
Do you recall weighing Miss Duval's son on July 22nd, 2010?
I never weighed Miss Duval's son.
Do you recall ever documenting that Miss Duval's son weighed 17.95 pounds on July 6, 2010?
I don't recall it specifically, no.
What does CWS/CMS mean to you?
That's, in this case, the delivered service log.
Okay, thank you. Okay, let me draw your attention to the last full paragraph on page 10. Please take a moment to read it.
Okay.
Let's go through. Let me start at the approximate second full sentence. The investigation disclosed SOI Sheele disregarded CP Duval's request for accommodations when she continued to document CP Duval's tremors, and SOI Sheele believed the tremors, quote, might be, end quote, due to CP Duval's stress when caring for her son. Do you see that?
Yes.
You disagree with that analysis?
Yes.
Why?
Because Ms. Duval never requested an accommodation, never showed me any medical documentation, never discussed it as a medical issue, and in terms of the might be due to CP Duval's stress, it is Ms. Duval herself who said the tremors are worse under stress. So yes, I do disagree with this.
Going down in the same paragraph to a line that starts, the implied diagnosis of possible Munchausen's by proxy. Let's stop right there for a moment.
Mm-hmm.
Do you agree with Ms. Hochstein that there was an implied diagnosis of possible Munchausen's by proxy regarding Ms. Duval?
No, I do not.
Did you see the upfront assessment?
Yes, I
That
did.
didn't understand
That's
you.
okay. Did you see the upfront assessment?
Yes, I did.
Did you see that there was a recommendation for a mental health examination to rule out Munchausen's by proxy?
Yes.
Did you see any subsequent documents filed with the court by DCFS which made a reference to possible Munchausen's by proxy on Ms. Duval's part?
It was mentioned, to my recollection, one time in the PRC report.
Okay. Does the number of times this condition may be mentioned important to you?
To me?
Yes, ma'am.
No.
If it was made without a medical exam justifying the diagnosis, it would be inappropriate to put this in any court report, correct?
Objection, incomplete hypothetical, speculation, calls for contention, calls for legal conclusion.
You can answer the question.
I was not writing this court report. I was not in ER at this time. I'm not qualified to answer that question.
So you don't think that, well, let me phrase the question this way. At this time, if you did not have a report from an appropriate healthcare professional regarding Munchausen's by proxy, would you insert possible Munchausen's by proxy into any client's records?
Objection, incomplete hypothetical, speculation, vague and ambiguous.
Would I insert it?
Yes, ma'am.
I would seek appropriate counsel as to whether to insert it or not.
Okay, but at this time, given all you know and all your experience, if there was a concern that a child had a low birth weight in a failure to thrive case, it's true, ma'am, that you would not yourself report that the parent had possible Munchausen's by proxy unless and until an appropriate healthcare provider had made such a decision, right?
Objection, foundation, incomplete hypothetical, speculation.
I don't know if that's correct or not.
So you would feel comfortable if you suspected Munchausen's by proxy by putting in the client's documentation that they had possible Munchausen's by proxy without a appropriate medical provider's report.
Objection misstates testimony.
You know, that's so hypothetical, I don't know how to answer it. I'm
Okay,
sorry.
I understand, but here's the bottom line. The civil rights investigator said it was wrong for the social workers to put in Ms. Duval's file that she suffered possible Munchausen's by proxy because there was no medical substantiation for the diagnosis. Do you agree with that? I'm not asking if you agree with the diagnosis, just the statement I just said.
Objection calls for a legal conclusion.
I'm lost on the question. Can you repeat it?
Let's do it again.
Okay.
I'm going to start in the middle of the paragraph and just read you a sentence, and you can tell me if you agree or disagree when I'm done. C.P. Duval is also protected as a qualified individual with a disability, parenthesis, possible Munchausen's by proxy, because she is a person who is perceived by others as having this impairment.
Objection calls for a legal conclusion, vague and ambiguous.
I'm sorry, I'm not done. The sentence isn't done. Though she has never received the diagnosis from a licensed medical professional. Okay, so stop. Now if you want to object, go ahead. I've asked the question though.
Objection, vague and ambiguous. Are you asking whether it says this, or are you asking whether she agrees with Hochstein's conclusion?
I'm asking if she agrees with Hochstein's conclusion because she's having a hard time understanding the same question asked orally.
Okay, so I'm going to make objection, calls for legal conclusion, foundation, assumes facts not in evidence.
Go ahead.
Okay. I don't know whether I can agree with her or not. I don't know that she is perceived by others as having this impairment due to what? I don't know.
Munchausen.
Okay, is she perceived? I don't know how she's perceived by others. Is she perceived by others as having it because it's mentioned?
But what I'm asking is this. I appreciate the fact that you've taken the next step and gone on to the perception. What I'm asking is, from your experience, was it appropriate for social workers in the department to document that Ms. Duval had possible Munchausen's by proxy when there was no report from a licensed medical professional?
Objection, foundation, assumes facts not in evidence, calls for legal conclusion, speculation, incomplete hypothetical.
They're quoting an upfront assessment, to my understanding. Should that be included? Wasn't there. I don't know. I wasn't there.
Okay, the other question
This is not my case at that place.
Right, and the other question I was asking you earlier, which we now can come back to full circle, is today, based on what you do, what you know, your experience, knowledge, and training, would you insert into a client's documentation that they had possible Munchausen's by proxy syndrome without a qualified diagnosis from a licensed medical professional?
Objection, foundation, incomplete hypothetical, speculation.
I would seek legal counsel
Okay, so you don't
on
know
that
the
issue.
answer.
I do not know the answer.
Okay. Okay, now let me just ask you if you agree or disagree with Ms. Hochstein's conclusions, okay? So you can just say agree or disagree, or explain as you see fit. Reading from a report, page 10, the implied diagnosis of possible Munchausen's by proxy led DCFS CSWs to recommend against family reunification for C.P. Duval with her son. Do you agree with that statement or disagree with that?
I don't know that to be true.
Does that mean do you disagree with it?
I disagree with that.
Okay, continuing. Although the court has not determined whether or not C.P. Duval is entitled to FR services, family reunification, right? I'm just defining FR. Yes?
Yes.
DCFS social workers are basing their recommendations upon the possibility C.P. Duval has Munchausen's by proxy disorder and continues to be a danger to her son by depriving him of proper nourishment.
Objection, speculation.
The question simply is, do you agree with that statement or do you disagree with that statement?
I disagree with that.
Next page, page 11. The investigation revealed CP Duval has suffered a delay of FR services, was differently treated in the receipt of services, and was denied some DCFS services because she is a member of the protected class disability, quote unquote. Do you agree with that statement or disagree with it?
Objection calls for legal conclusion. Speculation.
I disagree with that statement.
Okay. Let me draw your attention to another statement in the report. It's about 2 lines down. It says, in addition, the CP was thought to be responsible for neglecting and harming her son. So let me just stop and ask you this question. Based upon your experience with Ms. Duval, do you have the opinion that Ms. Duval was neglecting and harming her son?
I believe that's what the court found.
I'm asking you your personal belief based on your observations of Ms. Duval.
Objection, vague and ambiguous. Compound.
I believe the case was decided on the evidence that was the evidence having to do with Ms. Duval's care for her son prior to his being detained.
Okay. I get it. I'm simply asking you, ma'am, do you agree, disagree, or perhaps you feel you can't state, based on your observation of Ms. Duval, that Ms. Duval was responsible for neglecting and harming her son?
Objection calls for legal conclusion.
Based on my observations during visitation,
Yes, ma'am.
I'm not.
If you don't
Is
know...
she responsible? Based on that, I'm having trouble with
Sure.
what she's responsible for and the basis for that responsibility.
I understand. And what I'm asking you, as
Yes.
a experienced professional person
Mhm.
involved in DCFS, did you ever form the opinion, personally, when you were observing Ms. Duval interact with her son, that this mother has been neglecting and harming her son?
Objection calls for legal conclusion. Compound, vague and ambiguous.
I believed it was possible
Based on what that you observed?
based on what that I observed. Based on her rigid controlling interactions with the child, based on her ongoing pursuit of a reason for the child's condition other than his care, in her care. I had concerns, yes.
Okay, and I'm not sure I understood all of that, but
Okay.
are you talking about the low birth weight? I'm sorry, the low weight?
The low weight, the global delays, the overall physical condition of the child.
And in your experience, was there anything to suggest to you the child was otherwise healthy and it was solely because of the mother's conduct that the child suffered these conditions versus an organic condition the child had?
Objection calls for a medical conclusion. Medical expert opinion.
Right, that's a medical issue.
Okay, you don't know.
I don't know.
That's fine. Any of those pages in front of you, ma'am?
Certainly.
Thank you. All right, we'll keep moving along. That report kind of is repeated again and again, so this should be a little bit faster.
Okay.
We'll go ahead and mark exhibit number 14. I'm going to hand your attorney a letter dated July 31st, 2010. Ask you to review it when you're ready.
It's been about an hour.
Yeah, take a break.
Can we take a quick
Yeah.
break just before?
Absolutely.
next
Let's
conversation?
take a break.
We are off the record at 5:04 p.m.
Not ready yet. I don't think you need both letters unless you want them both.
I do need both.
Okay, then you're welcome to keep them both.
Thank you.
We are back on the record at 5:19 p.m.
Thank you. So we've had a chance to show you what we've now marked as exhibit number 14, which is a July 31st, 2010 letter from Ms. Hochstein to you. Do you see that?
Yes.
Have you ever seen the July 31st, 2010 letter of determination from Ms. Hochstein to you before?
Now I am totally confused
Why?
because I only received one letter.
So the answer is no.
I never received two letters. I see that they say different things. I'm not sure which letter I received, but I know that I did not receive both of these. I received one letter only.
Okay, let's go over this
Okay?
step by step.
Okay.
And I appreciate the fact that you did not see both letters.
Right.
So the first letter says that they sustained violations of national origin and disability. The
Yes.
second letter just says disability.
Yes.
Does that refresh your recollection at all?
I did not receive two letters.
But seeing that one has two violations against you and one has one does not refresh your recollection as to which letter you received.
The only thing I recall is disability. I
Okay.
do not recall national origin.
So it's, in your mind, it's more probable you got the July 31st letter.
That seems more probable to me.
Okay. Now, it says, although the investigation, I'm sorry, and we're focusing just on the 31st letter now. Although the investigation of Ms. Duval's complaint did not reveal a violation of her civil rights based upon her national origin, the matter is being referred to DCFS Performance Management for administrative review of potential violations of departmental policy. Do you see that?
Yes.
Now, let me first ask you, do you know who performance management is?
No.
Have you ever heard the term before?
I have heard the term.
Do you have any understanding of it?
I don't know what it means, no.
Okay. To your knowledge, were you ever referred to performance management?
Objection, speculation?
I'm asking to your knowledge.
I don't know if I was referred. She says I was referred.
Let me rephrase it since your attorney made an objection. To your knowledge, did performance management ever contact you regarding Ms. Duval?
To my knowledge, they did not.
To your knowledge, did performance management ever contact you regarding potential violations of any departmental policies at all?
I don't believe they ever did, no.
And just so I'm closing all this down, make it tight, you have never, to your knowledge, been contacted by performance management to discuss a violation of anything, right?
No.
That would be correct.
That would be correct, yes.
Did you ever receive a separate letter that it says will be forthcoming advising you of corrective measures to be taken by DCFS?
I did not.
Okay. You'd hand that to the court reporter. You show 1415, I'm sorry, 1314. I'm now going to hand your attorney an email, ask you to take a look at that. Let's get rid of these. Let me ask you to read that. When you're done, let me know.
I'm done.
Have you ever seen Exhibit 15 before?
I don't remember it.
To your knowledge, is your writing anywhere on that document?
No.
So, for example, the bottom where it has your name,
Yes.
that's not your writing.
No.
Thank you. You can go ahead and hand it to the court reporter. I'm now going to hand you the Second Amendment to Civil Rights Report of Investigation, which has been marked as Exhibit 16, dated August 2nd, 2010. It is 14 pages in length. I am handing it to your attorney. Want to pre-mark it?
Just always worried if somebody starts talking.
You've had a chance to review the exhibit,
Yes.
and we've asked you previously if you reviewed any amendments to the civil rights investigation. You can see from the front page this is the Second Amendment, correct?
Yes.
And you previously testified you were unaware of any amendments to the civil rights investigation by Ms. Hochstein, correct?
I've never seen this.
Right. You've never seen this before, have you?
I've never seen this before.
You don't even know where it comes from, right? Now,
Just sad.
I'm sorry, what?
I said it's very sad. It
What's-
makes me feel sad. That's
What-
okay. That's my stuff.
What makes you so sad about it?
I just feel sad that someone would feel that I discriminate against them. At the same time, not giving me an opportunity to do something different. So,
Are you talking about Ms. Duval or Ms. Hochstein?
probably both.
I see. Okay. So,
The issue of civil rights is a sensitive issue for me,
why?
obviously,
How so?
as I explained before. It's something I'm passionate about. So,
Obviously, you're a woman, right?
obviously.
Obviously. And as part of civil rights, women earn the right to go forth and work and vote and everything else, right?
The civil rights movement and the women's movement were a very big thing in this country. And yes, we have made a lot of gains as a result of it.
And that's why you support civil rights.
I support civil rights on its face because it's right.
Okay. So let's talk about this report for a little bit.
Okay?
Let me draw your attention to page 2,
Okay.
the bottom. Number
Yes.
5, it says disability. I want to talk about the last line. Let me know when you're ready to talk about it.
Okay.
It says, finally, her concern that her son may have inherited some of her allergies was cited as the reason she withheld food from her son. Do you see that?
Yes.
Do you have any understanding of where that language came from?
Objection, speculation.
I'm asking if she knows.
Son may have inherited. From where, like document?
Yeah,
What
like no.
document?
Who said it? It's in the report, but there's no source. Do you see that? So I'm not clear who said it, and I'm asking you. Did you ever say that? Or we'll get there. We'll eventually get there.
I don't remember this, so I can't say.
So you don't know if you told that to Ms. Hochstein?
At this moment, I can't recall, no.
You could have, you may not have, you simply don't remember.
I don't remember this statement, no.
Okay. Let me draw attention to page 5 of the report.
Yes.
Let me draw attention to national origin. Please read the entire 2 full paragraphs
Okay.
and the end of the page. We will be carrying over to page 6 if
Okay.
you choose to read the entire section. Let me know when you're done.
Yes. Okay.
Let me draw your attention back to page 5. We'll start there. Let me draw your attention to the second full sentence in the first paragraph under national origin. Although SOI Sheele's request for CP Duval to stop singing in Spanish to her son did not rise to the level of violation of CP Duval's civil rights, SOI Sheele's behavior could be perceived as culturally insensitive. Is this the first you've ever been told that your behavior was perceived as culturally insensitive?
In this report?
Ever?
Yes.
You understand that the author is saying that you behaved in a culturally insensitive fashion when
Right.
you denied the right for Ms. Duval to sing to her child in Spanish.
Yes.
So you're learning for the first time now that a civil rights investigator has determined you to be culturally insensitive, correct?
Yes.
How do you feel about that?
Objection, argumentative.
Well, could be perceived as culturally insensitive. Under some circumstances, perhaps it could be. Under these circumstances, I don't believe it was culturally insensitive.
Okay, let me draw your attention to the next paragraph where it says further. Let me know when you're there and you're ready.
Second paragraph?
Second paragraph under national origin.
Yes.
You're ready?
Mm-hmm.
Further, CP Duval recalled she made at least 3 requests for a bilingual monitor at the Lakewood office where SOI Sheele works because her family, including maternal grandparents, speaks very limited English. CP Duval noted that each time she made her request, she was told either there were no bilingual monitors available or they were working on it. Let me just stop and ask first. We've discussed this issue today. This document reports that there were at least 3 requests made by the mother to the department for a bilingual interpreter. Does that agree with your recollection of events?
I can't place a number on it, but I do know that Ms. Duval requested a bilingual monitor.
On more than one occasion?
I don't know.
Are there any limits on the number of languages the department provides interpreters for?
Objection, speculation.
I can rephrase the question.
We need to have staff available that can monitor in that language.
Do you know if there's any languages that the department is unable to provide a monitor for?
Objection, speculation.
I'm not aware.
Okay. Before we were talking about family and whether they have the right to a monitor, and I'm trying to understand this sentence, so please help me understand. If the mother appears at the Lakewood office to participate, strike that. If the grandmother appears at the Lakewood office to participate in a monitored visit with the grandchild,
Yes.
and the parent has an English election for their primary language, do you know if the department provides interpreters for the grandparents under those circumstances?
Objection, incomplete hypothetical speculation.
I think you need to differentiate between what is court-ordered and what is not court-ordered.
Yes, ma'am.
In this case, there are no orders for grandparent visitation. In some cases, there are. In this case, visitation is ordered for mother. Mother designated English.
Got it. So the primary driver of the interpreting services is what the court orders in combination with the party's election of language.
Yes.
Okay, thank you. Let's turn to page 6. Next page. If you look, they're ascribing a comment to you. It's the second full sentence on page 6. SOI Sheele stated, to properly understand what is going on during the monitored visits, she, meaning you, must be able to understand the language being used so she can intervene if CP Duval is saying something negative or making promises to the child. I'm confused. What promises could the mother be making to the child that would require you to intervene?
parents make promises to the children all the time, such as, after the next court hearing, you're coming home soon, mommy's bringing you home. That's very, very common.
Okay, so I understand, thank you. So if you're the monitor and I'm the parent,
Yes.
and my child is being monitored, and I do not have custody right now because I've been divested of that by the department, and you hear me telling my child in English that you're coming home after the next court hearing, it's a promise that I can't fulfill, what do you do?
I would,
Objection, incomplete hypothetical, speculation, assumes facts. You can answer.
if the parent is making promises of that nature, I'm going to quietly aside ask them, please don't make promises.
To stop.
Please stop. Don't.
And if the
And then we can discuss that after the visit, but I would ask them at that moment to please stop.
And if the parent persists in making promises that the parent can't fulfill, what happens next?
Objection, incomplete hypothetical, speculation.
That's an individual situation I would have to see and assess at the moment.
Do you ever go to the child and gently explain to the child that promise cannot be fulfilled?
Have I?
Objection, speculation.
Have you?
Oh.
I don't believe I have.
Okay. Now, one thing that's different in this report versus the last report is it says, in the same paragraph a little bit lower, SOI Sheele submitted DCFS Form 5120, monitors instructions, terms and conditions for supervised visits, which they attached as an exhibit to the report to support her statements. And then it appears you're defending yourself before Ms. Hochstein, saying that your behavior was in compliance with DCFS policy by highlighting item number 5. Did you provide this policy to Ms. Hochstein?
Yes, I did.
And do you recall asserting to her that your behavior was in compliance with item number 5?
I don't recall it specifically.
Sounds about right.
Sounds right.
Okay, there's a number of other policies made mention. It appears you also provided DCFS policy form 485. Does that sound about right?
Yes.
Now, the investigator points out that the form indicates the client's primary language, but does not take into account any other languages spoken by DCFS clients. Do you see that at the next paragraph down?
Can you give me which
Yes, ma'am.
line?
Do you see exhibit number 9 in the second complete paragraph? It's highlighted.
Oh, yes.
Or, I'm sorry, it's bolded in the paragraph.
Yes.
It's the line immediately above that.
Okay. Yes, I see it.
Is this statement correct? The form does not account for other languages spoken by DCFS clients?
485 is the primary language designation form. It designates one language for the case. Yes.
So
So yes, it does not take into account other languages.
the statement by Ms. Hochstein is correct.
Yes.
Let's draw attention to the last paragraph on page 6. It reports that, quote, the other parent is a better fit because he's willing to vaccinate the child, end quote. Do you ever recall having that conversation with Ms. Duval?
Telling her that the other parent is a better fit?
Yes, ma'am.
Absolutely not.
At the time of this investigation, were you unaware of whether or not California has laws regarding that children be vaccinated or not vaccinated?
Was I unaware of the California law?
Yes, ma'am. Well, I'm asking you first. Do you know if California at this time has a law that requires children to be vaccinated?
I don't know what the law is regarding vaccinations. As far as the law, we are not trained in the law. We are trained in policy to respect the parents' rights under the law.
When you remove
So when someone asks me the law, that's a different question.
I see, thank you. When you remove a child and put them in foster care, do you make any effort to verify they have their vaccinations?
Objection, incomplete hypothetical, speculation.
Do we make an effort?
Yes, ma'am.
Yes, we make an effort.
What effort do you engage in to make sure a child has their vaccinations?
We would inquire of the parents. We would inquire for their vaccination card. We would inquire for their doctor, where they receive their regular medical care, so that we can follow up.
Did you have any conversations with Ms. Hochstein during the investigation regarding Ms. Duval's long-term breastfeeding?
I don't recall discussing breastfeeding with her.
Do you have any, sorry, did you have any conversation, well first let me ask the term. What is attachment parenting, if you know?
Objection, speculation, calls for narrative.
Yeah, I don't know that I can give you a...
Okay. Have you ever heard the term before?
I have heard the term, yes.
What does it mean to your understanding?
Objection, calls for narrative.
It's, to my understanding, and this is just off the top of my head, attachment parenting is parenting with a concern for building the bond and the attachment between mother and child.
Okay, and you never discussed that with Ms. Duval, correct?
I don't recall discussing that.
Okay. In any way, did you retaliate against Ms. Duval for refusing to sign the case plan?
No.
That played no determination in your recommendations of any regarding her case?
That's completely her choice to sign or not sign.
Okay, let me draw your attention to page 7. Under disability, we will go to the second complete paragraph.
7. Mhm.
Let me know when you're ready.
Okay. You want me to read it?
I'll read it to you.
Okay.
The last sentence says, further, DCFS made the recommendation that CP Duval not be allowed to
Wait,
reunify...
I'm sorry. I'm on the wrong page, perhaps, on page 7?
Yes, ma'am. At the bottom, under disability. Second full paragraph. Yes, ma'am. Now if you go to the last full paragraph, last full sentence in the paragraph, it starts further. Do you see that?
Oh, got it, yes.
Further, DCFS made the recommendation that CP Duval not be allowed to reunify with her son. Therefore, CP Duval was differently treated in the receipt of services because she is a qualified individual with a disability, tremors, possible Munchausen's. Do you see that?
Yes, I do.
Let's take them one at a time.
Okay.
Do you agree with Ms. Hochstein that Ms. Duval was not allowed to reunify with her son because of a belief that she had possible Munchausen's?
No, I do not agree with
Objection,
that.
speculation.
Do you believe that Ms. Duval was differently treated in any way in the receipt of services because of her disability?
No, I do not.
Okay, page 9. We've already covered this. Let me just ask your understanding. If you look down in the middle of the paragraph, just above age, it has bold, SOI Sheele has not responded to the requests for this information. Do you see that?
Yes.
Now, this report is dated August 2nd, 2010. The last report was dated July 30th, 2010.
Yes.
And there was a discussion we had in the first report about timing. I realize it's about a 3-day difference, but it's in bold here. Do you have any understanding of why the same information from the first report is repeated in bold here?
I do not. However, when I just read through this, and I don't see it at this moment, I did see a response from me that was sent via email to Ms. Hochstein in her second set of inquiries. They were all together. They were all responded to at the same time. So I did notice that one of them was in here, and I would have to look for it.
You're talking about the exhibit list in the back, perhaps?
No, I'm talking about in here.
In the report?
Yes.
Okay.
But this one says not responded. However, I responded to all that second list at the same time.
Okay. There is a, if you turn to page 12,
Okay?
it could be what you're referring to. SOI Sheele subsequently responded to interview questions indicating yes. I am aware that Ms. Duval stated that she has allergies. I do not recall seeing any pictures or pictures of rashes on her son. End quote. SOI Sheele has indicated she received the Duval case in mid-December 2009 and spent over 19 hours monitoring visits between CP Duval and her son. On March 18, 2010, SOI Sheele documented in her service log notes, CP Duval, quote, cleaned the floor with wipes, end quote, before she and her son sat on the floor. SOI Sheele's documentation of CP Duval wiping dust and dirt off the floor of the visitation room did not rise to the level
Sorry.
of... Sorry.
It's too late to go that fast.
Sorry. Trying to squeeze it in.
I'm back at the wipes.
Okay, I got you. I'm ready. Before she and her son sat on the floor. I'll tell you what, let's just skip that. Read it to yourself. We'll save
Okay.
the reporter. Sorry for that. Do you understand that she's actually saying you did not commit discrimination when you documented that Miss Duval was wiping things off the floor?
Yes.
Is that what you were referring to a moment ago?
There's that one. There's the one below it that says I subsequently responded to interview questions stating I've never believed regarding being coached by Mother MGM. So these two, as well as the others that say I have not responded, they were all responded at the same time to the best of my recollection.
Now, let me draw your attention to the last full paragraph on the page.
Okay?
And I won't read it to save our reporters time. It's true, ma'am, that in the last sentence it says that the investigation revealed you did not discriminate against CP Duval on the basis of CP Duval's allergies. Correct?
Yes.
Let's turn to page 13. In the first full sentence on page 13, it's implying and stating that both subjects of investigation, meaning I believe you and Ms. Nelson, used CP Duval's statements of allergies to support their beliefs that CP Duval was responsible for her son's failure to thrive condition, implying CP has possible Munchausen syndrome by proxy and other personality disorders, even though you're not qualified to make such a diagnosis. Do you see that?
Yes.
You would agree that you are not qualified to put a diagnosis of Munchausen's by proxy in a person's records, correct?
I am not qualified to make such a diagnosis. Correct.
And you would agree that you are not otherwise qualified to diagnose any personality disorders of any type, right?
No, I'm not qualified.
Okay. Gesundheit.
Thanks.
Did you ever form the belief that Miss Duval's allergies were responsible for her son's failure to thrive condition arising out of the Munchausen allegations?
Objection, vague and ambiguous.
The last portion, repeat it?
Sure.
I didn't get the last
Did
portion.
you ever form the belief that Miss Duval's allergies were responsible for her son's failure to thrive?
It was a concern that her allergy fears led her to not feeding certain foods, but I would say the failure to thrive is far beyond that.
Okay, we have a few minutes left. I'm going to try and finish by like 6:15. We took a few breaks. Let's draw our attention to 2 more paragraphs down.
Mhm.
It discusses that this investigation revealed Ms. Duval was treated differently in the receipt of DCFS services based on her disability. And it says, the CP was held responsible for neglecting, abusing, and harming her son by withholding food from him because she was perceived by the SOIs as being impaired by MSBP. As a result, DCFS permanently removed CP Duval's son from her care and closed her case. First, do you see that?
Yes, I see it.
Do you disagree with those statements?
Yes, I do.
Do you have any understanding of why Ms. Hochstein formed this belief?
Objection, speculation.
I'm asking based on your experience in working with Ms. Hochstein.
Objection, speculation.
I do not.
Okay, and then at the bottom of this report, there's no recommendations for corrective action for you. Do you see that?
Yes. I would also like to point out this report is dated August 2nd. Court had made no conclusion at this time.
Understand. There's also a recommendation. There's also, strike that, a documentation that Lynn Condon, Lynnecondon, discussed your case with Ms. Hochstein. Were you aware of that fact?
I don't know who Lynn Condon is.
Have you ever met her?
No. Not to my knowledge, I've never met her, no.
Okay. Let's stop. I only have to go off the record. I only have 2 more documents to go through.
This is the end of media number 3 and the continuing deposition of Victoria Sheele, Volume 2. We're off the record at 5:57 p.m. We're back on the record at 6:01 p.m. This being in media number 4 and continuing deposition of Victoria Sheele, Volume 2.
Thank you, ma'am. We've given you a document to review. We've marked it as exhibit number 17. Your lawyers had a chance to review it also. You have the document in front of you, correct?
Yes.
You had a chance to review it?
Yes.
This is Civil Rights Report of Investigation Addendum, correct?
Yes.
You've never seen this document before, have you?
I have not.
This is all news to you, isn't it?
Yes, it is.
Okay, now this appears to be a September 9th, 2010 addendum to the August 2nd, 2010 report. Do you see that?
Yes.
You've never seen this before, right?
I have not.
Okay, let me draw your attention to page 2. Let me draw your attention to the bottom of the page. It says age discrimination. Below that, there's a quote attributed to you. Do you see that?
Yes.
Did you ever suggest that the mother, Ms. Duval, needs coaching by her mother to parent her child?
No.
Do you know where the statement came from?
No, I do not.
Okay. Let me draw your attention to the next page, page 3. To the conclusion section. We'll go to the second full paragraph. Let me know when you're ready. The small one, yeah. Although the investigation did not substantiate Duval suffered discrimination, and I'll skip on, SOI Sheele's request during a supervised visit for CP Duval to stop singing Spanish to her son is culturally insensitive. Do you see that?
Yes, I do.
So now you're back to being culturally insensitive again, right?
Apparently so.
But you had no information about all of this.
I've never seen this.
Okay, let me draw your attention to the paragraph, 2 paragraphs down from where we are. Let me start with the word however. Let me know when you have it there.
We're
Go
on
ahead.
paragraph number 1, 2, 3, 4.
Yes,
Where?
ma'am. Go
Number
ahead.
4?
Yes, ma'am. And I'm going to ask you about the word
Got it.
however to
Mhm.
the end of the end of the paragraph, so why don't you read it? Ready?
Yes.
Perfect. Again, Ms. Hochstein is reporting that you and Ms. Nelson are relying on statements of Ms. Duval's allergies to support your belief that Ms. Duval was responsible for her son's failure to thrive condition, implying she has Munchausen's and other personality disorders. Do you see that?
Yes, I do.
And again, she reports you're not qualified to make such a diagnosis, correct?
Yes.
And then she goes on to say, putting speculative information about CP Duval's presumed diagnosis and documents to be presented in court resulted in harm to CP Duval because she was treated as if she had MSBP without a diagnosis by a licensed professional. Do you see that?
Yes.
Do you agree with that statement?
No, I don't.
Why do you disagree with it?
I disagree with it on several levels.
Please tell me.
Okay. The first sentence, and I will only address my portion of this,
Of course.
that my statements about Ms. Duval's allergies support a belief that she was responsible for her son's failure to thrive. I disagree with that statement.
Why?
Because there was far more than allergies involved here. This child did not get to the condition he was in because of Ms. Duval's allergies, or her, that perhaps was a factor. Were there foods she didn't feed him because of concerns for allergies? I believe she stated that somewhere in here.
I'm concerned you said perhaps. I didn't follow you. What do you mean by that? Perhaps what?
Perhaps we're talking about to support the belief that she caused the failure to thrive. Perhaps she didn't feed some foods because of allergies. Your child still would not be in a failure to thrive condition because you chose not to feed certain foods.
Could also be perhaps because the child had an unidentified genetic disorder?
Objection, incomplete hypothetical foundation, speculation, and it calls for a medical conclusion.
I'm not a doctor.
So you can't say.
No.
Okay. On the bottom paragraph, you'll see she repeats this opinion that Ms. Duval was held responsible by the department for abusing and harming her son. Do you see that?
Yes.
And you still disagree with that?
Yes.
Okay, turn to the recommendations page, please, on page 4. And again, you see where it clearly says that you would benefit from cultural sensitivity training. Do you see that?
Yes.
It also says you would benefit from training regarding documenting observations in an objective and factual manner. Do you see that?
Yes.
Have you ever been told before reading this document that your documentation is not objective?
No.
Have you ever been told before reading this document that you do not document matters in a factual manner?
No.
And you've not undergone any cultural sensitivity training?
No.
Has everyone even suggested to you should undergo cultural sensitivity training?
No.
This is all brand new to you?
Yes.
Okay. Why don't you please hand that exhibit to the court reporter? Let me mark this as exhibit number 18 and hand it to your attorneys and to you when you're ready. We're on 18, right? Okay, wait. Before, you've had a chance to review this fax cover page, right?
Yes.
Let me draw your attention to the bottom of it.
Mm-hmm.
There's a strike that. There's a, what appears to be a signature or a name. Is that your name?
That's my name.
Is that your writing?
Yes, it is.
You wrote that.
I wrote Victoria, yes.
Did you make the smiley face?
That's not usually my style, but it's there, so perhaps.
Does it appear to be your smiley face?
I don't draw smiley faces on things.
Do you know where the smiley face may have come from?
I do not.
Take this back. In April of 2010, you were working at the Lakewood facility, correct?
Yes.
Do you recall if your fax number was 562-420-3607 at that time?
Have no idea what the fax number was.
This document says from Victoria Sheele, CSW 2. Correct?
Yes.
You were CSW 2 at that time?
Yes.
And you were working at Lakewood?
Yes.
Okay, thank you. You can go ahead and hand the document to the recorder.
That's actually part of the 3 pages to that.
Oh. This open letter?
The open letter.
Sorry.
These 2 pages. So you should keep them together.
Sorry. We'll mark everything. Take a look at that, please.
Okay.
And I have only one more document to go over.
Mm-hmm.
Can I ask you a question?
Sure. We'll be done in 5 minutes. Have you ever seen the letter that was faxed with the cover page?
Yes.
When do you recall seeing it?
I don't have a recollection of the date.
You recall receiving that letter, however, right?
I did receive the letter, yes.
You testified previously that you were unaware that Ms. Duval had some concerns about your monitoring of her case. Does this letter refresh your recollection in that regard?
I'm sorry, repeat that?
Does reading this letter refresh your recollection regarding whether or not Ms. Duval was concerned about the way you were monitoring her case?
Concerns about the way I was...
Administering, I'm sorry,
Manage-
monitoring. Yes,
Case
managing.
management?
Yes, ma'am.
Okay. Yes.
And what did you send the concerns to be?
Well, in here she's discussing... I don't know.
That's okay. Let me ask you this then. Do you have
What?
any understanding of why you would have faxed this document to Ms. Nelson?
Yes.
Why?
Because this would go to court, most likely. Mother stating concerns here. Court has a right to know her concerns.
Did you take any affirmative action to address the concerns you raised in the letter?
I would need to review the logs,
Yes, ma'am.
but I do recall telling Mother to obtain all the records directly from the hospital, because that is going to be your most complete copy.
Thank you.
Okay.
When you were talking to Ms. Hochstein, would you characterize the way you spoke to her as being nervous?
Objection vague and ambiguous?
Do you understand the question?
That I was nervous when talking to Ms. Hochstein?
Yes, ma'am.
I don't recall.
Do you recall appearing anxious during that period in time?
I don't recall.
Do you ever recall appearing very anxious to Ms. Hochstein?
That would be Ms. Hochstein's assessment.
Did you feel very anxious in your own, as you describe it, when you were talking to her?
I don't recall feeling anxious.
Gesundheit. Do you recall speaking to a Robert Budin, B-U-D-I-N?
Yes.
Why did you call him Mr. Budin?
He was Mother's therapist of record. So I called to confirm her participation in services.
Mental health services?
Yes.
And to your knowledge, were these services, strike that, to your knowledge, did these services begin before the child dependency matter?
I don't recall.
Did you provide him with a HIPAA?
Pardon?
Did you provide him with a HIPAA release?
For him to talk to me, he would need to have a release.
Did you provide him a HIPAA release?
I would assume, but I don't recall.
I can't find it. Do you have it in your records?
I have no records.
Okay. Did Mr. Budin tell you that he was not concerned about Ms. Duval's parenting?
I don't recall that.
Did Mr. Budin share with you that Ms. Duval is vulnerable given her position with the department?
That letter was reviewed with me yesterday, and I don't recall most of what's in there, if any.
Do you recall ever seeing that letter before?
I did not see that letter before, to the best of my recollection.
But do you recall the conversation?
I know that I had a conversation with him.
Did you ever tell Mr. Budin that you saw Ms. Duval as your enemy?
That I saw Miss Duval as my enemy?
Yes, ma'am.
No, sir.
Do you believe that Ms. Duval saw you as her enemy?
Objection, speculation.
And based on your observations of Ms. Duval?
Same objection, speculation.
I'm not sure that enemy is the right word.
Okay. What word did you use?
I think she felt a level of conflict.
Thank you. Let me ask you this final series of questions. With regard to this investigation, are you aware of any discipline whatsoever as it relates to your employment with the County of Los Angeles?
No.
We've covered a series of documents here today that you've never seen before, right?
Yes.
And you now understand that the county civil rights unit was making findings about your performance, don't you?
Yes.
And you were totally unaware of those findings until today, right?
I was not totally unaware. I received a letter
Right.
that substantiated.
But for example, you had no information that someone had recommended you undergo cultural sensitivity training until
No.
today, correct?
That's correct.
Okay. At any time, did you become aware of your position with the County of Los Angeles becoming in jeopardy because of this investigation?
No.
At any time, did anyone advise you you could be terminated for this conduct?
No.
At any time, did people tell you that you were on a path to termination if you continued this conduct?
No.
This is all news to you.
Yes.
Let me show you what we'll mark as exhibit number 19. Hand to your attorney. Please take a moment and review it. Let me know when you're ready.
Okay.
Have you ever seen this document before?
No, I have not.
Were you aware of the fact that you were recommended to go on a path that if you committed 2 more similar offenses, you could be terminated?
No.
This is news to you.
Yes.
How do you feel right now?
Objection, argumentative.
I've been surprised a lot today.
May I have that back for a moment? Let me ask some questions about that. Do you know, strike that, you've never spoken to the performance management section for the county, correct?
I believe I have.
In what regards?
I never heard anything, and I think I think I talked to someone there. This is all sort of confusing to me of who all these different people are. I don't know who I talked to,
Okay.
but there was like, I'm a little proactive, you can tell.
Little what?
Proactive.
Okay.
Like I would be inclined to say, you know, is there something I'm supposed to do? I
Right.
didn't receive any letter.
Right.
And I, again, long time ago, I don't remember details, but it was like, there's nothing you need to do.
But being proactive, because Ms. Contreras said don't follow up with Ms. Hochstein, never followed up with her after that last phone call, right?
Pardon?
With regard to the letter you received,
Mhm.
saying you'd received more information,
Right.
because Ms. Contreras, thank you, said let it lie, you never followed up with Ms. Hochstein to find out what further information was forthcoming, right?
Not because of anything Ms. Contreras said to me,
Why?
because that wasn't the nature of that conversation.
I see. And you've never spoken to Mr. George Smith, right?
No.
Are you aware of the fact whether or not these documents are sent to the state of California for review?
Objection, speculation?
I'm asking if she knows.
I recall something about things being sent to the state for review, yes.
And for approval?
Whatever they do with it, I don't know.
And you were completely ignorant of this document before today, correct?
Yes.
And to your knowledge, you're not on a termination path at this time?
It would be a surprise to me.
Okay. Anything else that you want to tell me that we haven't discussed here today?
This has been more than enough.
I understand. Do you have any spellings? No, we can go off the record for that. All right, I propose that we just use the stipulation from the last deposition reported by our reporter, if that's agreeable with you.
The volume 2 of El Pinedo's deposition?
Wasn't there volume 1 of this deposition?
I don't believe there was a stipulation at volume 1.
Oh.
Oh, I apologize. We didn't stipulate yesterday. We just went off the record.
Oh, you did?
Yeah.
Okay, I was. All right. So let's just agree to Ms. Pineda's final
Okay,
stipulation.
regarding that we can keep the original?
Yeah, everything was the same.
Okay, yeah, that's fine.
Perfect. Ma'am, thank you for your time. We're done.
No, actually, the keeping the original, I think, was the custody control is supposed to remain with the court reporter. That's the only deviation, I think, from the standard.
That was with Pender and Rogers, but with Ms. Pinedo, that Mr. Prager was, he stipulated to.
I didn't know it was an issue.
You're in control today.
Yeah, I'm in control today.
Okay.
That's fine. Same stipulation.
Hold on. One concern.
Are we still on or
Now let's
off?
go off the record.
Yeah.
We're off the record?
All right, so the end of meeting number 4 concludes volume 2 of the deposition of Victoria Sheele. We're off the record at 6:22 p.m.